Yes. What? Okay. Okay.
Ones that are not. All rise. The Circuit Court of Dickson County is now in session. The Honorable Judge David Wolf is presiding. All ye have business for this court trial now, and ye shall be heard. God bless the United States, this state, and this court. You may be seated.
All right, good morning and welcome to the Michael J. Flanagan birthday docket that we have today. Mr. Flanagan is the walking embodiment of the old saying that I think one of our former rock and roll stars said, if I'd have known I was going to live this long, I'd have taken better care of myself. So, all right, we have a couple of matters I need to take up first. The first docket, first cases will be on page 10. 2024 CR 109, State of Tennessee versus Jamie J. Clark and Kristen Clark. We have Ms. Wilkerson and Mr. Lockhart. Good morning. It's my understanding that there are motions that need to be heard in this case that have not yet been resolved or heard. Is that microphone on?
It is now.
No.
The forensic interview motions will need probably better part of a day for that. And then we just need a trial date, which we're gonna need probably about 4 or 5 days.
When was this case set for trial?
It was the second to last week in July. I think it was the 20th or the 24th.
And it was set for, okay, it was set for July the 20th, so why don't we just do the motions on that day?
Oh, does that work?
I mean, you should all be available on that day since it was for trial that day.
For the state versus Stewart.
Yeah.
He's here.
All right.
He's gonna have to. Still.
Well, anyone who is involved in this case needs to be here on the 20th of July, and we will do the forensic interview motions. But we expect it to take a day, but not two, right?
I don't think it'll take 2, Your Honor.
All right. Anything else then in this case?
Do we need to so will we just pick a trial date on that day?
Now, let's go ahead and set it for trial. Do we have September dates available? That's my next term of court. What about, have we set things on the 28th and 29th already?
I don't have anything.
Missy, do you have any idea if we have things set on the 28th and 29th? What are they? We have the State versus Cordarius Godwin on the 24th and 25th, is that according to my calendar? What holiday is the 25th of September? No, we're looking at setting it in for trial in September. So on the 28th of September, what do you have? Oh, that's a criminal trial, right? Okay. That may be a case that I have recused myself from because I think one of the alleged victims is a clerk over in another county. So I need to check on that. Is the Cordarius Godwin case going to go for sure that we know? Well, let's set it for January the 20th and 21st.
Thank you,
All
Your
right.
Honor.
Thank you.
2025, this is on page 18, 2025 CR 26, State of Tennessee versus Zhang Fan, Xian Fan. Mr. Turner,
Judge, that is Mr. Kraft, and he has stepped back. I believe he's talking to Mr. Fan right now.
well, I knew he needed to try to get out of here as quickly as possible.
Yes, Judge.
Then we'll move to page 32. And on page 32, the State of Tennessee versus Hunter W. Jackson. We have him in custody. Bring him out. All right. This is for arraignment. You have a copy of the indictment. We are. All right, Mr. Jackson's here to be arraigned on an indictment charging him with count 1 with premeditated first-degree murder, and count 2, he is charged with felony murder. Are you representing Mr. Jackson?
I am, Your Honor.
Do you wish a formal reading of this indictment, or do you?
No, Your
want-
Honor. We wait for more reading.
All right, formal reading of the indictment is waived. A plea of not guilty is entered. At this point, we need to set it for status. General, do you have a time, and you want to set it for the September status date? What were you saying? September 8th for status. At that point, hopefully all the discovery can be completed and we can talk about a trial date.
Yes, Your Honor.
All right, thank you. All right, we're going back to page 18, 2025 CR 26, State versus Jian Fan.
He's in lockup.
Everybody out, Mr. Fan?
He's going to sign this guilty plea, and then we'll be ready to move. I appreciate your accommodation.
No problem.
Your Honor, may I approach? Or, I'm sorry, excuse me.
Madam Interpreter, let us place you under oath and administer the oath, please. All right. I have been handed a document indicating that Mr. Fan wishes to enter a plea of guilty to count 2 of the indictment, a felony conspiracy to commit theft. And upon his plea, he would be sentenced to 3 years in the Tennessee Department of Corrections, would be ordered to make restitution of $113,000 to Christine Bond and $5,027 to the Dickson County Sheriff's Office. And this would be concurrent with any federal sentence involving the same conduct. He would receive pre-sentence jail credits from April 16th, 2025 until today. Have Mr. Fan raise his right hand and let the clerk administer the oath.
The only thing I would add, he's a range 1 offender and he's 30%, Your Honor.
All right, it is indicated, so
I just wanted to make sure that was marked properly.
it is. State your full name for the record. Okay. You are here today charged with a 2-count indictment. Have you seen or been shown a copy of those charges and talked them over with your lawyer and discussed with him the range of punishment you're facing, as well as any possible defenses you might have?
Yes,
Do you understand that you have a right to plead not guilty and to have a speedy and public trial by jury? Do you understand that, Mr. Kraft, if you'll point that towards so we can pick up the Madam Interpreter, please. Do you understand that at trial you would have the right to have a lawyer appointed to represent you if you cannot afford your own?
I understand.
Do you understand that at trial you would be presumed to be innocent until such time, if ever, the state proved your guilt beyond a reasonable doubt to the satisfaction of all 12 jurors, and their verdict would have to be unanimous before you could be convicted of anything?
I understand.
Do you understand that at trial, you and your lawyer could confront and cross-examine all witnesses the state brought in, and you could bring in your own witnesses by using a subpoena.
I understand.
Do you understand you would be presumed to be innocent, and you would not have to testify or prove anything, and no inference of guilt would arise because you did not testify?
I understand.
Do you understand if you went to trial and you were found guilty, you could appeal the decision as well as the punishment to the Court of Criminal Appeals and have a lawyer appointed to help you with the appeal?
I understand.
Do you understand that by entering this plea, you are waiving your right to a trial and to an appeal?
I understand.
Do you understand this is going to result in a felony conviction which will be on your record in the future to make more severe the punishment you will receive if you are ever again convicted of a crime?
I understand.
Do you understand everything I've explained to you so far?
I understand.
Do you want to plead guilty according to this agreement and waive your right to a trial and to an appeal?
No.
I'm sorry, repeat that?
There are immigration consequences or likely immigration consequences. They've been explained. And if you ask, I didn't hear. I
I
apologize.
didn't, but we're about to. Do you understand that your immigration status can be affected by this plea of guilty and your conviction for this crime? That's all right.
I understand.
All right. Do you understand that, is this a straight-up guilty plea, Mr. Kraft? All right.
I'd also say
Understand. Do you understand if you plead guilty, the court or the state may ask you questions about this offense, and if you answer these questions under oath on the record in the presence of your lawyer, your answers could later be used against you as a prosecution for perjury if we find you were lying under oath?
如果在这个法庭上你做了有罪的答辩，你所讲的话呢，也可以被用在联邦法庭的起诉之下。了解吗？ I understand.
Do you understand, or is your decision to plead guilty today voluntary?
那么你今天是自愿的要答辩，对吗 ？Yes.
Anyone forcing you to do this against your will?
有没有任何人逼迫你 ？No.
Do you understand I must have facts to support a finding of guilt in this case?
你知道此案的确是？Yes.
I'm sorry, we've muted the
He said
Dickson
yes.
County Jail, all right. Then listen as the state tells me what their evidence would be if this case went to trial. I assume that's simpler than asking him to, all right. General Bryson?
那么州政府会有能够提供事实和证据，来证明你有罪。
Judge, the victim in this case, Christine Bond, lived in Dickson County. She received a pop-up message on her iPad and through resulting conversations ended up getting $25,000 in Bitcoin, $58,000 in cash, and delivering that to an individual in the Big Lots parking lot here in Dickson County. She withdrew an additional $35,000 in cash for a second pickup, but law enforcement was involved. They were able to stop the individual who was acting as a courier for that second pickup. Statements of that individual and examination of that cell phone led them to investigate Mr. Fan. Mr. Fan was sending the courier instructions and was instrumental in arranging travel for the courier. And as part of that, even though he never came to Dickson County, he was involved in this conspiracy.
Do you understand those are the facts the state would prove at trial? Are you satisfied with your attorney's services?
你对于你的律师满意吗
I am satisfied.
You believe your lawyer has done a good job of representing you competently?
你认为你的律师对你的代表非常好？
After you know of any reason he should not enter this plea?
你有没有任何理由知道会有这个答案？
I understand.
是他最好的利益。
Anything further from the state?
No, Judge, as long as it is clear on the record that his attorney has admonished him and the court has admonished him that he will very likely be deported.
I would expect that there is a 100% probability that Mr. Fan will be deported to where I do not know, but he will be deported, I'm sure. So. All right. Then Mr. Fan, upon his plea of guilty to count 2, I find him guilty. Sentence him to 3 years in the Tennessee Department of Corrections. He is to serve that as a range 1 offender, and that will be concurrent with any federal sentence that he has involving the same conduct. He is ordered to pay restitution of $113,000 to Christine Bond and $5,027 to the Dickson County Sheriff's Office. He is granted pre-sentence jail credits from April 16th of 2025 until today. That's the judgment of the court.
这就是本庭的判决，好不好？
I'm sorry. Oh, that's all right. Good luck with your appointment. All right, we're going to go to the Cheatham County Jail. I'm going to ask you to unmute your device, please. And this is Mr. Seth Hall. On page 24, this would be Mr. Seth Hall. We have a motion to suppress in this case, if I understand correctly. Is that motion to suppress set for hearing?
Judge, the motion to suppress is not actually for Mr. Hall. I think Mr. Hall is the one represented by
Mr. Brown?
Mr. Brown, and he has not joined in that motion with the other 2 co-defendants. I expect Mr. Massengill and Mr. Spratt to have some sort of announcement on if they're filing a subsequent motion or if we're going forward.
I know
with
Mr.
theirs.
Brown was in our pretrial conference with the lawyers, and indicated he had some other place to be, but what were we doing with this case? Resetting the status day to September? All right, September the 8th.
Well, do we have motions to hear? Or state needs to know whether I need to be ready on a motion that day or not.
Anticipate amending. We just received the videos. I received them yesterday. Mr. Spratt will be here shortly, but there's a few issues we want to run
Pull that
down.
microphone up.
Yes, Your Honor. A few issues we want to run down, and if we get to a point where we don't think that, there's a few issues where if we don't think it's gonna be viable, we will strike, but we don't feel that we're at a place where we can do that yet, Your Honor.
So to summarize, you have a motion to suppress that's already been filed,
Yes, Your Honor, but there's some
and you're
issues.
expecting that it will be amended, possibly depending on the new discovery you've received,
Yes.
and that prior to a date to hear, you will give the state adequate notice of whatever your intentions are regarding the issues you're going to litigate.
Absolutely, Your Honor.
And we need to, have we set it for a hearing? That's the other issue.
Well, that's what I was asking, if
I'm
the next.
interpreting from Mr. Massengill
Yes.
for you, General. so-
Yes, thank you. I need to know if that September date is a status to get a motion date, or if that is my motion date.
Well, we haven't heard anything from the lawyers. Harry versus- You know, what about setting, what does your August day look like? I'm looking at August the 8th or the 15th to set these motions. Or set this motion, whatever.
I was gonna say those are both Saturdays.
I'm sorry, the 7th or the 14th, 7th or the 14th, thank you.
Well, I have a trial with Your Honor on August the 6th that is probably going into the 7th. But the
Oh,
14th,
I have that, what did we set on that day?
it's a Mr. Younger and I believe Mr. Tate are the co-defendants there. It's a drug case.
Well, we can do it with the district clerk, their office is open. That's election day, I know that we said it
Okay.
at some point. Oh, that's right. We were gonna reset this case because of the election day, and Pam Myatt Lewis is not available on that day. So what are the cases you want to set? Is it a one-day case?
The trial,
Yes.
I believe it to be a 2-day.
Well, that's my fault. I said it when I felt like we could do it, and I didn't check with all of the powers that be. What about the 14th?
I can, for the trial or the motions?
Motions.
Motions, yes, Judge, I can do those on the 14th.
That's good for me as well, Your Honor.
All right, so this will be the State versus, what is your client's name?
Billy Ray Perry.
And Mr. Spratt represents James Dubois, or Dubois.
We'll let Mr. Brown talk with Mr. Hall about whether or not he wants to join in, but if he does, then they'll be set on that same day. And then the status for the case will be on September the 8th. So the motion to suppress is now going to be set on the 14th of August. The status for those cases will be on September the 8th. General, when we're at a break, let's talk about a date to reset that trial, if necessary, that's set on the 7th or the 6th,
Yes, Judge.
Thank you, Your Honor.
all right? Mr. Hall, your lawyer had to be somewhere already, and we've talked with him about it, but your case is going to be set for the September 8th as a status day, and you can talk with him. If he wants to join in the motion to suppress, then that will be heard on the 14th of August. Thank you.
Yes, sir, thank you.
All right. Can we set the Dickson County Jail? All right, it's the Dickson County Jail. You want to bring in one of your inmates, we'll start that. In the meantime, I will start through the regular docket here. All right. Good morning. What is your name, please?
Hey, Brown.
Wrong one.
Hey, Mr. Wolf. I've got a program that I've been trying to get accepted to. It's at Lakeview Women's Mission. I have a daughter I'm really trying to get home to. I've served 110 days, and I'm asking to go home today.
Well, you're here today to be arraigned on an indictment that charges you with theft of property and driving on a revoked or suspended driver's license. And the first thing I need to deal with is, do you wish to have a lawyer represent you?
Yes.
And was the public defender appointed at the lower court on this case?
Yes, sir.
Okay. Public defender will be appointed to represent you, and then, Ms. Brown, you'll need to talk with him about any issues that may have arisen.
What is his name?
Ms. Brown, my name is Zachary Talbot.
Zachary Tomlin.
Talbot.
Talbot.
T-A-L-B-O-T. He's with the public defender's office, and he'll be up to talk with you as quickly as he can, and he'll address whatever the issues are that you're saying you need to talk with him about.
I acknowledge receiving a copy of the indictment and waive formal reading of the same on behalf of the defendant. She's entering a plea of not guilty.
Plea of not guilty is entered. Do we set it for September 8th for status?
Yes, sir.
General Bryson? All right, September 8th for status. All right, thanks, Brown.
Does that mean I gotta wait till September 8th?
Your September 8th date is for the status. If your lawyer talks with you and you can get something worked out earlier than that, then you can go ahead and take care of it more quickly. Other than that, I'm giving you until September the 8th for your lawyer to do an investigation, to do a discovery motion, and then file any appropriate motions. And then on September the 8th, if the case is not resolved, I will give you a trial date.
All right. So his name is Zachary Thompson.
Zachary Talbot, T-A-L-B-O-T.
Does he got a number?
He'll come see you. I'm not going to give his telephone number out over the Zoom link.
All right. He's gonna see you today.
I can't tell you that. He's going to be here with me until late into the afternoon or evening, because we have a lot of people here who I have to deal with. So if you'll step back with the officers, he'll be up to talk with you.
All right. Well, thank you. Is he coming?
Page 2024 CR 138, State of Tennessee versus Ashton Ryan Algard. Mr. Potter.
We do not have anything negotiated to settle this case. Today is a status day. There have been a few motions filed by my office on Mr. Algard's behalf. There's a motion that I know of that we're filing regarding the seeking medical records, counseling records, and so there is a Rule 412 motion that's been filed regarding the alleged victim in this case. So my suggestion, and the state may be seeking to introduce a forensic interview if there is one that they wish to, I don't know, it hasn't been filed, but my suggestion would be that we get a motion date in this case, would be the next thing, please.
What about August the 7th?
I'm not available that month. That month we're having the federal trial regarding the Waverly flood. It starts August the 4th in federal.
Regarding what?
The flood that happened in Waverly in 2021.
What about the 7th? Let's see. Did I say anything on the 17th of July? Okay. State versus Estes. And there's a motion. What about the 31st of July?
Yes, sir.
Is that all right with you? All right. So Mr. Algard's motions will be heard on the 31st, and then the status will be still September the 8th, and we'll assign a trial date at that time.
Thank you, Judge.
Or are you ready to set a trial date, General? We have a medical emergency.
Sit down, Judge.
All right, General, do you want to go ahead and set a trial date or status on September the 8th? All right. All right. So on the 31st of July, we're going to hear the motions, and then after the hearing on those motions, we'll assign a trial date if necessary.
Yes.
All right.
Yes, sir. Thank you.
All
Mr.
right.
Algard, you can leave. I'll be in touch with you.
All right, at the jail, what is your name, please? You have to unmute.
Brittany Hale.
Since my client, if we can bring her down, we may have a disposition.
All right, Ms. Hale, your lawyer has asked for you to be brought down, so we're going to bring you down.
Okay.
And see if your case can be resolved. Thank you. We'll see you down here in a little bit.
Okay, I'll start bringing the guys in, Judge.
All right, thank you. All right, at the jail, there, the other Zoom link. Can you tell me what your name is?
Michael Cohen.
All right, Mr. Cohen, you're on page 11 of our docket. Mr. Cohen, you're here to be arraigned on an indictment charging you with possession of methamphetamine with intent to sell, simple possession of a Schedule III drug, possession of unlawful drug paraphernalia, and theft of merchandise by shoplifting. You have the right to an attorney. Do you wish to have a lawyer represent you?
Yes, sir.
Public defender will be appointed. Officer, if you'll hand this to the public defender, please.
I acknowledge receiving a copy of the indictment, waive formal reading of the same, and on behalf of the defendant, enter a plea of not guilty.
Plea of not guilty. General, you want to set a status date of September the 8th? September 8th for status.
Yes, sir.
Your lawyer has been appointed. He'll be in touch with you. You're in Hickman County, is that correct?
Yes, sir. And may I ask my attorney's name?
Zachary Talbot, Talbot.
Okay, thank you.
All right.
You said September 8th?
September the 8th. He'll be in touch with you before then to talk about your case, all right?
All right, thank you, sir.
Thank you.
I'm okay to go? All right.
All right. On page 1, 2026 CR 59, State versus Charles Edward Adams Jr. He's in jail, I'm sorry. The next case, 2025 CR 257, State versus Crystal Aldridge. It's this Honeycutt's case.
I believe need to, I mailed earlier this week a order to waive the diversion fee with her
I
being.
think I signed it, so.
Okay. And then there's a little bit more discovery we need to do, and there's discussions about offers out there. So if we could just set this for status.
That would be September the 8th.
Okay.
Thank you.
Thank you, Your Honor.
On page 3, 2026 CR 26, State versus Benjamin Preston Ashley.
Judge, that's Mr. Atchison. Okay, to understand, we filed a Rule 43 waiver. We didn't enter a plea of not guilty on that case.
Mr. Atchison is the attorney. Plea of not guilty is entered. This is set before a different judge, so the plea date is July 17th, trial date is July 20th.
Thank you, Judge.
Thank you. All right, at the jail,
Hello, Your Honor. How are you doing, sir?
I am, it doesn't matter how I'm doing at the moment. What is your name, please?
Jordan Bays.
Mr. Bays is on page 4. Thank you for asking, but it's been a little bit of a confusion here, so.
I understand.
Bays, you are here to be arraigned on a charge, an indictment charging you with theft of property and theft up to $1,000. It's a 3-count indictment. You have the right to an attorney. Do you wish to have a lawyer?
No, sir. I wanted to plead guilty to it from the get-go. I didn't know how you would do that.
Well, I'm going to give you a bit of advice.
Okay.
You may be wanting to plead guilty of this case and try to get it resolved as quickly as possible, but by pleading guilty, you're subjecting yourself to a punishment that you may not know and may not want. If I appoint a lawyer for you, they can explain to you what your rights are. They can explain to you what the defenses you might have, and they can tell you what the range of punishment is, and they can negotiate with the state to get what they consider to be the most fair advantage and disposition of your case, fair to both you and to the victims of the theft. So if in view of that, the public defender is available, and I can appoint them to represent you if you would like.
That'll be fine, sir.
Appoint Mr. Talbot with the Public Defender's Office to represent you.
Yes, sir.
Now, Mr. Bays, I'm going to give him a copy of that indictment. He has Mr. Baker, I failed to give you a copy of the Ashley indictment. Can I hand that to you? All right.
Your Honor, I acknowledge receiving on behalf of Mr. Bays a copy of this indictment and waive formal reading of the same. The defendant enters a plea of not guilty.
A plea of not guilty is entered. We'll set it for status on September the 8th. However, if you are able to resolve this case more quickly, you can dispose of it on VOP day this month if you wish to do so. I know he was indicating he wants to try to plead guilty, so.
Sir.
All right, he'll talk with you and try to get this case worked out for you, okay?
Thank you.
All right.
Right there. Thank you. What's up, Mom? All right.
Good morning. What is your name, please?
Christopher Bateman.
Mr. Bateman, you're here today. I think Mr. Nathan Brown is your lawyer.
We met him on September 8th, which was his plea date.
All right. Mr. Bateman, your lawyer was here earlier this morning and had to leave and go to another appointment. So we had discussed with it. He's still working on your case, but it is reset for September the 8th, and he'll be in touch with you to discuss it with you and explain to you, okay?
All right. Thank you, sir. You have a good day.
Thank you. 2025 CR 62, State versus Eric Lee Allage and Toby Allage. Mr. Waynick, case.
Jeff Petty. They're all 3 co-defendants.
Is this one of the cases we talked about this morning?
We just need a trial date on this.
All right, so they are charged with assault with bodily injury, aggravated assault. This is, I'm talking about Eric Aldridge. And then there's also a Toby Aldridge is charged with aggravated assault, bodily injury, and false imprisonment. And then Mr. Petty is charged with assault with bodily injury. All right. So you need a trial date. Everybody understands once we set it for trial, it'll go to trial, plead to the indictment. Obviously, that means that all plea agreements are off the table. Mr. Potter, can I see you for a second? You have the last floor case. I thought I had accused myself that they were telling me it's set, so. All right, thank you. So, Missy, you have a trial date of the 28th for State versus Lance McClure, but that's not me, that's a different special judge. So do I have anything set on the 28th?
Judge, we expect this to be.
28th of September. All right, 28th and 29th of September.
Judge, just so we're clear, is there, would the 30th be available too, or is there something scheduled?
Well, the 30th, you're thinking it's going to be a 3-day trial?
It's going to be 2 full days, possibly 3.
Well, the 30th is our criminal VOP day. I would hate to not be able to hold that, so. And General Wojciechowski, our criminal conspiracy cases are all set for the October 19th through the 23rd, correct? And they are still a go? You have any plans for Thanksgiving?
Trial. It's a rough week to do a trial, I'll tell you.
I was just looking, December 28th, 29th, and 30th, in between Christmas and New Year's. Everybody loves, pardon? And we think the daycare cases are going to take a, what about the 28th and 29th of January?
Fine with me to do the 30th if it falls into it.
The 30th is a Saturday, and I'm disinclined to, I'm not Judge Birch, so I don't try cases on Saturday unless I have to. So
I just want you to know we're willing.
we just need to make a note when we do the 2027 calendar that the first day of the first Monday in September, I'm sorry, first Monday in February may have to be reserved for the bleed of this trial. All right, so State versus Eric Lee Aldridge, State versus Toby Aldridge, and State versus Perry, Jeffrey Petty. All of those cases are set on a combined trial on the 28th, 29th of January.
Thank you, Judge.
All right, at the jail, what is your name, please?
Hunter Bishop.
All right, Mr. Bishop is on page 6 of the docket.
Go to the VOP day of the 27th to see.
May 27th.
Yes, sir, see if we can get it resolved.
We're going to pass you to the VOP day on May 27th to let your lawyer see if he can resolve your case.
Can you hear me?
Yes.
Okay, I'll be up to see you tomorrow night at 8 o'clock.
All right. Thank you. Thank you, sir.
Mr. Bishop, you can step out.
All right. Thank you.
2025 CR 298, State versus Jenny Louise Beal.
That's my case in the I think the state's gonna move to nolly those cases, Judge.
Yes, Your Honor.
All right, on State versus Jenny Louise Beal, the state has moved to nolly. The cases are dismissed.
Thank you, Judge.
Thank you.
Oh, no.
All right. At the jail, what is your name, please?
Joseph Bly.
All right, Mr. Bly is on page 6. Mr. Bly, you're here to be arraigned on a charge in 2026 CR 57 with especially aggravated stalking. In 2026 CR 58, you're charged with especially aggravated stalking and harassment. You have the right to an attorney. Do you wish to have a lawyer represent you?
Yes, sir.
All right, public defender. You have an indictment to hand now. All right, we'll hand you a copy of the 2 indictments. You wish a formal reading?
No, sir. On behalf of the defendant, Mr. Bly, a plea of not guilty should be entered.
Plea of not guilty is entered, set for status on September the 8th.
Thank you, Your Honor.
Your lawyer will be up to talk with you and discuss the process that needs to be done to get your case ready, and we'll see you again in court on September the 8th unless you resolve it earlier. Thank you. 2025 CR 101, State versus Jernisha and Marquita Birdsong. Ms. Smith?
To General McElroy yesterday, we're missing some discovery. So if we could get another review date to give us time to obtain that discovery, please, sir.
All right, September the 8th.
Where it's on. Free to go. Your Honor, I have another case that's an announcement.
All right, what is it?
Oh, Michael Ware.
You know what page he's
I
on?
do not, Your Honor, but he is very much near the back as he is a W.
56, page 56 of 59. Michael Ware, docket number 2023 CR 333. Ms. Smith, what do you
Yes,
wish
sir.
to do?
The issue, Your Honor, is that we had agreed to complete reciprocal discovery one-on-one with my expert. We haven't had an opportunity to schedule that yet, so we will need another date.
All right, this is where your expert was going to review the images that were the basis for the state's charge of sexual exploitation of a minor.
Yes, sir, and also the method in which they had been stored on the computer itself.
All right. We'll reset you for a status and final plea day on September the 8th.
Thank you, Your Honor. That concludes my business.
All right, thank you. At the jail, are you Brian Carmona?
Yes, sir.
Mr. Carmona, you are here today to be arraigned on a charge of probation violation. You have the right to an attorney to represent you. Do you wish to have a lawyer?
No, sir.
You understand that you, may I see the All right, you are here today charged with violation of your probation. It's alleged that you were placed on probation for a period of 1 year on or about December the 5th of 2025 for the possession of Schedule 7 drugs. And it's alleged that you have violated your probation by violations of Rule 1 in that you would obey the laws of the state of Tennessee and the United States. It's alleged that on or about April the 18th of 2026, the Dickson County Drug Task Force conducted a motor vehicle stop and observed you operating a vehicle. They conducted a search of your vehicle where they found you in possession of 10 THC carts and pink-colored pill identified as oxycodone. You were arrested and charged with possession with intent to resell, deliver, or manufacture a Schedule 6 drug. Do you have a lawyer on that new charge?
Yeah, on my new charges.
Who is that?
Mark out of Olin Baker's office.
Mark Atchison.
Sir.
I'm going to give you a piece of advice. I know you said you don't want a lawyer, but you're entitled to have a lawyer on this charge as well. So I'm going to appoint Mr. Atchison to represent you as well on this indictment or this affidavit of violation of probation. Mr. Baker, I'll hand you a copy of that. I've partially read the formal charge. Do you wish to waive a formal reading?
We'd waive the reading, Judge, and enter a not true on the allegation.
Entered a not true, okay.
I think technically that's probably.
All right, so we're going to enter a not true plea on your behalf, and we'll set it for the VOP day, which is the 27th. No, May. You want to put it off since he has that other case?
Let's don't. I'll let Mark figure that out.
27th of May. All right, we'll set you for May 27th and let your lawyer see if he can work any magic to resolve all of your charges. So, all right, thank you.
All right, thank you.
At the Humphreys County Jail, if you can hear me, if you've got someone there, I believe one inmate that we're ready to take up. Hold on just a second. And are you Billy Jameson?
I am.
All right, he is on page 33, so let me find it first. Mr. Saul, you represent Mr. Jameson?
I do, Judge. He's a co-defendant with Mr. Cotton and Holbrooks, as well as Mr. Shelton.
This is his status and plea day, final plea day.
It is, Judge. He's currently being held in Waverly on some new charges. I know that one of his co-defendants has a date of May 20th with Ms. Stevens. I don't know if we could put Mr. Jameson on that day for May 20th and see if we can get a resolution.
Judge General Crouch is handling this case. Not all of the defendants have even filed for discovery at this point, and so he asked that it be moved to the September status date. I can put it down on that other date if that's what you would like, but Judge, he was asking for September.
I don't care. We have a criminal docket on May the 20th with motions. And if you want to set it on that day, but go ahead and set a
September date would also be fine, because I know he's got other things he's working on.
All right, we'll set it on May the 20th and then again on September the 8th.
September 8th. Thank you, Judge.
All right. All right, we'll see you on May 20th, Mr. James.
Thank you.
All right, at the Dickson County Jail then, are you Joshua Christian?
Yes, Your Honor.
Christian's on page 9. Mr. Christian, you're here to be arraigned on a charge of probation violation. You have the right to an attorney. Do you wish to have a lawyer represent you?
Yes, Your Honor.
All right, I will appoint the public defender. Public defender is being given a copy of the affidavit of violation. Do you wish to plead not true?
Not to be dramatic, but he'll plead not guilty.
Not guilty, all right.
Yes, sir.
Then we'll plead not guilty and set it for hearing on the 27th day of May.
It's set for June
In June?
29, sir.
All right, so we've set it for the June VOP day, which is what?
June 29, sir.
June 29th. All right,
Thank you, Your Honor.
thank you. We'll be up with you and get you ready for your hearing in June.
Thank you.
All right, good morning. Are you Corey Cooper?
Yes, sir.
Mr. Cooper is on page 11. Mr. Cooper, you are here today to be, I think you filed a motion, a pro se motion for jail credit.
Yes, sir.
You may.
Thank you, Your Honor. I asked to be heard because it's my understanding that Mr. Mitchell with the Public Defender's Office, the Public Defender, Mr. Mitchell, he is working on this credits issue already.
All
So
right.
I would simply request the appointment from the court.
Well, I'm going to go ahead and appoint the public defender. I can't calculate your credit for time because obviously we got too many irons in the fire, but I'm going to appoint the public defender's office to represent you. And it's my understanding, Mr. Mitchell, the public defender, is already at work on this issue. So he will continue to work on it and they'll be appointed to represent you and help you with your issue regarding the credit you're entitled to, okay?
Yes, sir.
All right, thank you.
Thank you.
Appreciate it. Thank you. Hey, can I go now? Can I go now? Yeah.
Good morning. Are you Cameron Diggs?
Yes, sir.
Diggs, you're here to be arraigned on an indictment charging you with tampering with evidence, threatening to commit an act of mass violence, stalking, and harassment. You have the right to an attorney. Do you wish to have a lawyer represent you? You want a lawyer?
Yes, Your Honor.
Public defender will be appointed to represent you.
In this case, we were conflicted out, or are conflicted out of this because of the identity of the
All right.
victim.
Well, we will start down the list. We'll appoint Mr. Mark Atchison to represent this defendant. Mr. Baker, standing in for Mr. Atchison, would you allow us to appoint your office?
What was this person's name?
His name is Cameron Diggs. It is a threat of act of mass violence against the residents of NHC Healthcare.
Okay.
All right. Mr. Diggs, your lawyer is Mr. Mark Atchison.
And on behalf of Mr. Diggs and Mr. Ashton, acknowledge receipt of a 4-count indictment, enter a plea of not guilty to all counts, and we'd waive reading of the indictment.
All right, plea of not guilty is entered set for status on September the 8th. Your lawyer will be notified of his appointment. He'll be up to talk with you after he has been able to get information about your case to see whether or not it needs to go to trial or be resolved by an agreement.
Does Mr. Diggs have a bail set? Do we know?
I don't have the file, Miss Missy. Well, there's
Thank you, Judge.
All right, Mr. Diggs, your lawyer will be up to talk with you. Thank you.
Thank you.
All right, good morning. Are you Jonathan Duff?
No.
Mr. Duff is on page 16 and 17. Mr. Duff, you're here to be arraigned on a probation violation.
I'm not Mr. Dev.
Oh, I'm
This is
sorry.
not
What,
Jonathan Duff, Your Honor.
what's his name?
Sir, what's your name?
Timothy Duran.
Okay, he skipped over. Mr. Durant's on page 17. I apologize. Mr. Durand, you are here to be arraigned on a charge of criminally negligent homicide, tampering with evidence, and making a false report to a police officer. You have the right to an attorney. Do you wish to have a lawyer represent you?
Yes, sir.
Have you had a lawyer previously representing you in this case?
No.
Public defender of the victim in the case is alleged to be Terry Dobbinspec. Any reason your office knows you could not represent him?
No, sir.
All right. Public defender's office will be appointed to represent you.
Your Honor, I acknowledge receiving a copy of the indictment and waive formal reading of the same. On behalf of the defendant, a plea of not guilty.
Plea of not guilty is entered, except for status, September the 8th. Mr. Duran, your lawyer will be up to talk with you and get you ready for either a trial or disposition. We'll see you again on September the 8th, and if it's not resolved on that day, I will assign a trial date.
All right.
Thank you. Good morning. What is your name?
Chaz Green.
Mr. Green is on page 21 and 22.
This is a case that I took over from Mark Odell, so I'm a little bit behind in it. There's been an offer made if we could go to the May 27th VOP date to allow me to talk to him further.
All right, we're going to give your lawyer time to work on your case, and I'll reset you for the May 27th VOP docket to let him see whether or not it can be worked out.
Chaz, I'll be there tomorrow night to see you.
All right, yes, sir. Thank you.
Come on, Mr. Green. I'll be here tomorrow night to see you. Great.
Good morning. What is your name?
Richard Greer.
All right, Mr. Greer is on page 22.
We need a trial date.
All right, we need a trial date. September 28th and 29th. Mr. Flanagan, does that date work for you?
It does.
All right, Mr. Greer, we're setting your case for trial, and once I set it for trial, you'll go to trial on that day or plead to the indictment, set for trial on September the 28th.
Good to see you, Richard.
Oh, looking for a bond here.
Mr. Flanagan will be up to talk with you tomorrow night, and he'll talk with you about the other issues that you want to talk about. So,
All right.
good morning. What is your name, please?
Roger Howard, Jr.
Mr. Howard is set on page 29 and 30. Mr. Howard, you are here to be arraigned on an indictment charging you in 2026 CR 77. You're charged with aggravated 911 calls in non-emergency situations and a failure to appear. In docket number 2026 CR 78, you're charged with domestic assault. 2026 CR 79, you're charged with violation of the sex offender registry form. And in CR 80, you're charged with evading arrest. You have the right to an attorney on all of these charges. Do you wish to have a lawyer?
Yes, sir. Yes, Your Honor.
Public defender will be appointed. Public defender, and this is Jennifer Stribling's case, Assistant District Attorney Stribling. So are we setting it on the September 8th day for status?
It being her case, I assume it would be an
That's why I
August
was
or
asking. It doesn't have a date.
August or
You want to set it for the, you want to set it for the June, what's your June June criminal docket? You want to set it for June, or do you want to set it for August?
June's fine, Your Honor.
They're setting it for status. June 17th. All right, your case is reset for June 17th to give your lawyer an opportunity to work on getting familiar with it and talking with you about the facts of the case. So they'll be up to talk with you as quickly as possible and go from there. We'll see you June 17th.
Who's the lawyer? Do they know?
Zachary Talbot is the assistant public defender who's here in the courtroom, and it may be him or it may be one of the other staff. They have a number of very highly competent attorneys that are working for the public defenders. Mr. Talbot is the one that's here in the courtroom today.
Well, they told me in general session that they give me Stephanie Lowe. She said that I had a conflict with the public defender's office.
Well, we'll see if that conflict arises, then I will appoint someone else, but we'll, if Ms. Lowe needs to be appointed, I'll do that, but
I do have sorry to interrupt, Your Honor. I do have a note here about the name of the victim here. I was unsure of the date of birth of the victim, but if we've conflicted out of it in General Sessions Court, then that means that we verify that conflict.
We will appoint Stephanie Lowe to represent this defendant, since she was appointed below because of a conflict, and we'll still leave it set for June 17th. All right, Ms. Lowe will be notified and she'll be up to talk with you.
Yes, sir. Yes, Your Honor. June the 17th.
June 17th. All right, well, we're waiting on the next case at the jail. Let me take up 2025 CR 265 State versus James Keith Beck II. I'm sorry, he's in jail. All right, who do we have at the jail now?
Dwayne Johnson, Judge.
Johnson's on page 33.
It's you right, sir.
Mr. Johnson, you are here on a pro se motion for relevant records being withheld by the City Dispatch Control Center.
Yes, sir.
Judge, that's being handled by General McElroy, who had to be in another court this morning. He'll be here later on in the docket.
All right, let's just bring Mr. Johnson down. We're going to bring you down so you can make your argument about what we're dealing with. The assistant that's dealing with your case is not here at the moment. He'll be here later in the day. So I'm gonna have you brought down so we can figure out what's going on.
I appreciate it, Judge.
All right, thank you.
Thank you.
Good morning. Are you Christopher King?
Yes, sir.
Mr. King, your lawyer wants you to have be brought down, so we will put you on the list to bring down at some point. We'll see you then, okay?
Okay.
Good morning. What is your name?
Thomas Lane, sir.
All right, you are Thomas Lane, is that correct?
Yes, sir.
All right, is your lawyer, Mr. Flanagan?
Yes, sir.
So it's already set for a final plea day of September the 8th and trial on October 19th.
Yes.
All right. Your lawyer says that your case is still set for trial, and we'll see you on the final plea date, which is September 8th, and then the trial date is already set for October the 19th through the 23rd.
Okay, sir.
Mr. Flanagan will be in touch with you.
All right, thank you, sir. Oh, boy.
Good morning. What is your name, please?
Harvey Lewis.
Mr. Lewis, you are here today to be arraigned on a charge of probation violation. You have the right to an attorney. Do you wish to have a lawyer represent you?
Yes, sir.
Do you want a lawyer?
Yes, sir.
All right, public defender will be appointed. Just hand him the copy. We're going to give your lawyer a copy of the affidavit, pardon me, a violation of probation, and all right, we'll make a copy of that. May I see the original? All right, this is alleged that Mr. Lewis, that you were placed on probation on June 18th.
Oh,
I'm
Your
sorry,
Honor, on behalf of the defendant, Your Honor, we can waive that.
Thank you.
Yes,
Your lawyer has waived the formal reading of the indictment, or the affidavit rather, that charges you with that. We're going to give him a copy of it. We'll enter a plea of not guilty and then set you for hearing on May 27th.
Thank you, Your Honor.
May 27th. Your lawyer will be up to talk with you and get you ready for that hearing.
Yes, sir. Thank you.
Thank you. Good morning. What is your name, please?
Ronnie McCoy.
Mr. McCoy, your lawyer is Sonny Stevens.
That's correct.
This is one of the conspiracy cases.
Possibly have a resolution, and Ms. Stevens asked if we could place him on May the 27th.
All right. Your lawyer is in another court, but she's asked that you be moved to May 27th. So I'm going to put you on May 27th to see whether or not your case can be resolved.
Okay.
We'll see. All right, thank you.
Right in there. And what your name is, tell me your Mr. Lane, sorry.
Morning, what is your name, please?
Christopher Lane.
All right, you are Christopher Lane.
Yes, sir.
Lane, you're here to be arraigned on an indictment charging you with violation of the sex offender residential and work restrictions, as well as violation of the community supervision with a criminal offense. You have the right to an attorney. Do you wish to have a lawyer represent you?
Yes, sir.
We'll appoint the public defender to represent you. I'm going to hand you a copy of the indictments in this case. General, is this your case? Is this the case involving the Christian school? It's not. Okay. All right.
Your Honor, on behalf of this defendant, go into a way formal reading of this indictment and what you
Plea of not guilty is entered. Status day will be set for September the 8th. All right, September the 8th is the new status day, and your lawyer will be up to talk with you, get you ready for a trial or disposition if possible.
Thank you.
Good morning. What is your name, please?
Patrick Meadows, sir.
Patrick Meadows is on page 40. Mr. Meadows, you're here to be arraigned on a probation violation warrant. You have the right to an attorney. Do you wish to have a lawyer represent you?
Yes, Your Honor.
Will appoint the public defender to represent you, and they're being given a copy of the charges against you.
On behalf of the defendant, I acknowledge receiving a copy of this warrant and waive formal reading of the same. He enters a plea of not guilty.
Plea of not guilty is entered, set for hearing May 27th. We'll see you on May 27th. Your lawyer will be up to talk with you and get you ready for that hearing.
Yes, Your Honor. Thank you.
Morning. What is your name, please?
Preston Milburn.
Mr. Milburn, you are here today to be arraigned on an indictment charging you with aggravated assault resulting in death and reckless homicide. But we show that you have a lawyer, Mr. James Brian Lewis. All right.
And upon receiving a copy of the indictment, we'll waive formal arraignment, enter a plea of not guilty, and ask for the status date of, I guess it would be September 8th.
September 8th. Your lawyers are here, or one of your lawyers are here, and he has been given a copy of the indictment. A plea of not guilty is entered. We set you for status on September the 8th. Thank you.
Thank you, Your Honor.
Thank you.
Good morning. What is your name, please?
Kenneth Ogg.
Mr. Ogg, you are here today to be arraigned on an indictment charging you with 2 counts of theft of property. You have the right to an attorney. Do you wish to have a lawyer?
Yes, sir.
Or as we know, has the public defender had any conflict with Mr. Ogg? All right. Then we will appoint the public defender to represent you. Howard, you're being given a copy of that indictment. You wish to inform a reading?
No, sir. We'd waive a formal reading and acknowledge receipt. Mr. Ogg has applied for drug court, and we are attempting to get him into drug court. He has a pending BOP.
All right. So do you want to set it for the September date or an earlier date?
September would be fine. We would like to reach a global resolution.
All right. September the 8th will be for status on this case. If he's admitted to drug court, you can take care of it in front of any judge. All right. Thank you. They'll be up to talk with you, Mr. Ogg.
Thank you.
Daniel, come back up here.
Good morning. What is your name, please?
Mr. Ray.
Mr. Ray, you are here to be arraigned on a charge of probation, actually a violation of community corrections. You have the right to an attorney. Do you wish to have a lawyer represent you?
Yes, Your Honor.
I will appoint the public defender to represent you, and the public defender is here in the courtroom. We'll give him a copy of that. Do you wish a formal reading?
No, sir. On behalf of the defendant, he'll enter a plea of not guilty.
Plea of not guilty is entered, set for hearing May 27th.
Who's my public defender?
My name is Zachary Talbot.
Zachary Talbot.
Yes, sir. Thank you.
They should be in. Did you hear something? Okay. Yeah, they give you another day, or what did they do, sign their lawyer?
Good morning. What is your name, please? What's your name?
Casey Robinson.
Okay.
Mr. Robinson is on page 47. Mr. Robinson, you are here today to be arraigned on an indictment charging you with 2 counts of theft of property. You have the right to an attorney. Do you wish to have a lawyer represent you?
Yes, sir.
Is Mr. Robinson, a single indictment, he doesn't have a co-defendant, does he? He is a co-defendant with Mr. Ogg, and you've been appointed to represent Mr. Ogg. So. All right. We'll appoint Mr. Nathan Brown, who is not here today, to represent, he's not here at the moment, to represent Mr. Robinson. I'm going to appoint a lawyer, Nathan Brown. Mr. Talbot, do you mind standing in for him for arraignment? So Mr. Nathan Brown will be appointed to represent you, and he'll be notified of that appointment and get up to speak to you. We're going to give for purposes of arraignment, do you wish a formal reading of the indictment?
No, sir, and he'll enter a plea of not guilty.
Plea of not guilty is entered, and I think we set that for September the 8th for status. So your lawyer will be notified. He'll be up to talk with you about the case and get you ready for either a disposition or a trial date.
Yes, sir.
Thank you.
What date will my court date be?
Right now, it's September the 8th. Mr. Brown may change that if he is able to work something out in your case. He can get it earlier if necessary.
Yes, sir. God bless you.
All right, thank you. Good morning. What is your name, please?
Patrick Tucker.
All right. Mr. Tucker is on page 54 and 55. Mr. Tucker, you're here to be arraigned on an indictment charging you with domestic assault, stalking, as well as knowingly violating a condition of your release. Then that is indictment number 2026 CR 49. In CR 50, you're charged with harassment in violation of a no contact order. In 51, you're charged with aggravated stalking. In 52, you're charged with especially aggravated stalking. You have the right to an attorney. Do you wish to have a lawyer represent you?
Sir.
Have you had a lawyer in your case so far?
I don't know.
Okay. Public defender will be appointed.
Your Honor, I acknowledge receiving a copy of the indictment and waive formal reading of the same. The defendant enters a plea of not guilty.
Plea of not guilty is entered, set for status September the 8th. Your lawyer will be up to talk with you and get you ready for either a trial or a disposition in your cases. Thank you.
Hey, will you take this one back out while you go?
Yeah.
Good morning. What is your name, please?
Sir,
What is your name?
James Watts.
Mr. Watts, you have a pro se motion for jail credits. And since I am unable to calculate your jail credits, I'm going to appoint the public defender to assist you in trying to resolve the issue about your jail credits.
Yes, sir.
The public defender is appointed and they'll investigate, calculate, and if there needs to be an agreed order to modify your jail credits, then we can do it that way.
Your Honor, I'm advised that our office has determined that this is an issue with TDOC credits for good time or work credits, and this court would not have any authority to.
I don't have authority to tell the Department of Corrections what credits to give you. So under those facts and circumstances, Mr. Watts, I'm sorry, but there is really nothing I can do for you to help you.
Yes, sir.
It's all with the Department of Corrections.
Yes, sir.
All right. Good luck with dealing with them. All right.
Mr. Wolf, that's everybody up in jail.
All right. Thank you very much.
Very welcome.
I know we've got a in-person bring down jail docket, but let's run through the regular docket first. It would appear now that we're on page 7. 2023 CR 192, State versus James Edward Boyd. Public defender's case.
Yes, Your Honor. Mr. Boyd His case has been set for status because he has a health issue. And we would ask that this court be set.
Yeah, it's a continuing status. And Judge, last time he was here, you ordered that he did not have to appear in person.
I think I remember that, so.
Judge, he keeps getting calls telling him to come to court, and it's not from my office, it's not from the public defender's office. Is that like an automated court? Okay. Okay, can we turn off that automated call, because that's why he keeps coming to court? Thank you so much.
Thank you. So on that note, if we could go to the September 8th status date for review, that would be appreciated.
Yeah, I agree. Why don't we just put it on the January date instead of September?
Yes, sir.
And that is what, January the 8th? January the 13th. January 13th for status. And if you can disconnect any automated phone calls, I'll give you a list of numbers I need you to work on for me. So 2025 CR 124 State versus Stephen Garrett Bria. Public defender.
Yes, Your Honor. Mr. Bria is here today. He's got a kind of issue with his surgery on his ankle, so he's moving slowly. But, Your Honor, this would need to be set for a trial at the court's next opportunity, which I assume would be September.
We're looking at September. Can we put it behind the Cordarius Godwin? Cordarius Godwin, we're gonna go. We tried, is that the one we tried? He's gonna want to. Whose case is this? General Sylvie, what do you have in October? Are you available any of those days? What about the 9th of October? This is a one-day case, correct? Mr. Talbot?
Yes, sir. That's fine.
All right. This would be the State versus Stephen Garrett Bria. How do you pronounce your name?
Bray, Your Honor.
Bray, okay. All right, we will have a trial on October the 9th here in Charlotte. So.
Thank you, Your Honor.
Twenty 2025 CR 261 State versus Juan Esteban Brooks.
In this case, Your Honor, we have an agreement to potentially get this to a resolution ultimately, Your Honor. Mr. Brooks is getting necessary mental health treatment, and I've discussed this with the state. There's an agreement for this charge to be retired for 2 years, provided that there be status reviews every 4 months on Your Honor's docket. Pursuant to this, Mr. Brooks would have to execute medical releases to allow the state to review his medical records. He would have to follow all of the treatment directives he's given by his mental health treatment providers and keep his mental health appointments, and that he have, importantly, no new arrests during that 2-year period.
Amen.
And Mr. Brooks would like to pursue this resolution of his case.
Mr. Brooks, you understand what we're doing in your case, and I know you've been here before, but you understand this is an opportunity for you to put this behind you and get some help with whatever issues you may have.
I appreciate it.
And all that's going to mean is you got to stay out of trouble, don't get any new arrests, stay in touch with your lawyer, and come in for reviews and sign the medical releases that we need to have signed.
Appreciate you, Judge.
That's a fine. You may be the only one in this courtroom who feels that way. So, in any event, we'll go ahead and put him on September the 8th, which would be the 4 months down the road.
Yes, sir.
So what that means, I'm going to be seeing you for 2 years, every 4 months. Okay? You're going to be like part of my family. So I hope you will do whatever you're supposed to do and make sure that you can get the mental health that you need, as well as make sure that you've signed all the necessary documents, because if you don't, then you're going to be right back in here looking at going to jail, okay?
I ain't got time for it, Judge.
All right. And we will see you on September the 8th.
Thank you, Your Honor.
I think we need to have a written order prepared.
Yes.
That'll reflect all of those conditions, as well as, you know, the review dates, and it's being retired, but it's also being reviewed. So,
Yes, sir.
all
Will
right,
do.
Thank you.
Thank you, Your Honor.
2025 CR 90, State versus Patrick Bucciarelli. August 7th, did I say anything on August 7th? Can we do these motions in one day? I know it's a 412 motion,
I believe so, Your Honor.
because it's being set on a Friday. August the 7th,
Judge, we can't do August, because Mr. Potter's in. And I can't do it without it.
so do I still have Dickson County Thomas versus VITDAO? What about October the 30th?
Yes, sir.
That works for the state, Your Honor.
This will be for your motions, and then do you want to go ahead and set a trial date in January? Or do you want to just wait to do it?
I think we can get a trial date after we hear the motions.
Oh.
I agree.
And one thing, too, the state wants to address, we filed a motion for reciprocal discovery. And I believe Mr. Flanagan has stated if we do go to trial, they anticipate putting on 2 days of proof. I would just like a potential witness list by October 30th from the defense.
Okay.
Yes, sir.
Thank you.
You're not alone. There are a lot of people who would like to have that opportunity. So. (2026) CR 90, State versus Nicholas Adam Butler. Brandon. Yeah, do that, because I may not see you unless you throw something at me. So. Mr. Butler, you're here to be arraigned on an indictment charging you with evading arrest or by flight, by vehicle. You have the right to an attorney. Do you wish to have a lawyer?
Yeah.
Are you planning on hiring a lawyer? Raise your right hand. Let's place you under oath.
Yes.
I'm going to have you fill out an affidavit of your income and expenses for me to determine whether or not you qualify to have appointed counsel. It's not an automatic thing. So you'll be signing this under oath, so make sure that it's accurate, because it would be perjury to file an inaccurate affidavit. Have a seat, and when you fill that out, you can give it to one of the bailiffs and we'll come back to you. On page 9, 2025 CR 266, State versus Tyler J. Chambers. Public defender. You may. Can you mute? We're setting September the 8th
Yes, Your Honor.
for status. On page 10, I think we've already dealt with the Clark cases. On page 11, 20, yeah, he's in jail, I think. I have him in jail for review. We'll come back to him. 2025 CR 192, State versus Cody Allen Corbin. Public defender.
Your Honor, this is Mr. Corbin. This case is close to settlement. However, there's some discussion still about the restitution that will be owed. May we please have the September 8th status date?
State have any problem with that? September 8th. Make sure you stay in touch with your lawyer, Mr. Corbin. 2026 CR 76, State versus Nicholas Harden Creech. Oh, he is incarcerated? And you know where? All right, let's set him for May 27th since it's an arraignment. So put him on the May 27th docket for arraignment. 2023 CR 229, State versus Ted Bradley Davenport.
That's the state's motion to continue.
All right, we're ready on the state's motion to continue this. Who was the other person?
Miss Erica Tidwell Davenport, that's on page 54.
54, okay.
Judge, I had filed a motion to continue and then an amended motion to continue. I am well aware of the age of this case and the motion for speedy trial and the court statement at its last setting that it needed to go. When I requested subpoenas more than a month in advance of trial, they were served, and Brent Allen, who was the state's designated witness on this case, has a trip that had already been planned and paid for prior to receiving his subpoena. He is a material witness and is unavailable. I recently received photographs from Mr. Allen of the victim in the R, which I've provided to the defense. My office has obtained a judicial subpoena for follow-up medical records from Dr. Mark Stubblefield and have not yet received these records. Once I receive them, I will need to provide them to the defense. Also, as the court is aware, the victim in this case, Mr. Townsend, has been incarcerated in the Cheatham County Jail since November of 2024. Some of that time he has been receiving evaluations, including an inpatient evaluation at MHI. That has presented some unique challenges in speaking with the victim that I would not normally have. I did meet with the victim on May 11th, on Monday, with his attorney, Mr. Lockhart, to discuss this case and to discuss trial prep. And on that date, I became aware that he may have received treatment at a different hospital that I was previously unaware of. Medical records that I currently have did not allude to this treatment. As of the filing of this motion, there were 10 business days before trial, which leaves me very little time to attempt to obtain new records and to provide them to the defense in advance of trial. For the following reasons, the state has asked the court to continue it. If this motion is denied, the state will go forward with whatever proof it has on the day of trial.
And the proof that you're lacking and the reason for your continuance motion is what exactly?
So one, the officer that responded to the ER to speak with Mr. Townsend, to get his statements, to observe his state of mind.
But your victim, Mr. Townsend, is available.
My victim is available to be transported. I do have additional motions, Judge, that pertain to the court allowing him to appear not in jail clothing and to appear in clothing provided by Mr. Lockhart, and also regarding questioning about charged but not convicted criminal conduct.
All right. Mr. Wainick?
Judge, if I get to the right motion, on behalf of Miss Davenport, Erica Ann Tidwell Davenport, this morning we filed a motion to dismiss the indictment based on the state's motions to continue. On January 7th, as the General alluded to, January 7th we were here, and I believe the court ordered that this case to be tried or it will be dismissed because there were prior continuances granted due to witness issues. I completely understand that there was a vacation that had been planned and paid for months ago. I do not want to wreck anyone's vacation. However, I think both defendants in 2024 had filed a demand for speedy trial, and the state waited until, I think, April 22nd to ask the clerk to issue subpoenas. So we filed a motion to dismiss because they filed a motion to continue, and the order was it would be continued. When it would not be continued, it would be tried or dismissed. That is our position.
Mr. Vandervoort?
Some of the same arguments. However, there were telephone records that were supposed to have been produced. We don't have those. Now we're being told there's medical records, additional medical records, and it has been pending for 3 years. Quite frankly, as I understand, the alleged victim is not cooperative in as much as he's been filing competency issues with the state for the last 2 years, dealing with his own 8 to 10 cases that he's got pending between Cheatham County and Dickson County. So as I understand, Mr. Lockhart no longer represents him. It's Mr. Flanagan. I'm also understanding that it's a situation where...
No, I still represent Mr. Flanagan as second chair.
Okay, thank you for that clarity. But at any rate, I don't know if he's cooperative or not. But certainly the court said on January the 7th that if we either try the case or the case would be dismissed, we're asking to proceed, or obviously the court has the ability to dismiss the case if the state is not ready.
Well, I'm going to take a short recess, look through this file, and try to refresh my memory on exactly what the problem has been. Do you have the docket? This is on Erica and Tidwell Davenport. We'll be in recess for 15 minutes.
All rise. This court's now in recess for 15 minutes.
All right, I need to go back on the record with the Davenport matter. Ted Bradley, Erica Tidwell, Davenport. I have reviewed the file and considered the arguments that are being made in the case. It is this court's opinion that where a motion for speedy trial was filed in 2024 in this case by the defendants, and the court then set it for trial in January with the instructions that it would go to trial, be tried or dismissed. I do not believe that I can legally or ethically grant a motion to continue the trial, and therefore the matter will remain set for trial on its current trial date of May 28th. I understand that may hamstring the state's prosecution of the charge, but where it has been pending for this length of time, I mean, the offenses, I think, occurred in 2023, so allegedly in 2023, and we're now 3 years after the alleged events taking place, and it's this court's opinion that a motion for speedy trial preempts all other considerations, and therefore this case will remain set. And therefore renders your motion to dismiss moot because I am not continuing the case. So, remain set for trial May 28th. Well, I don't want to hear anything on the morning of trial, so you need to hear the motions. You'll have to hear them on the 20th. All right, the sentencing hearing in the State versus Sarah Fuson is being reset off the 20th, so that opens up, and that was, I think, the motion for new trial, rather, not the sentencing, but the motion for new trial. So we can set this, whatever motions you have in this case, on the 20th as well. All right, who was it I need to do? Mr. Potter, you have something I need to take up? Well, apparently it is, because a lot of things are being reset, so I think it's going to be basically the same situation. Is it basically motions that need to be heard, Mr. Potter? All right. Okay, well, let's set it for September the 8th, and if we can't resolve it, we've got another criminal docket on the 23rd of September. So. Well, you want to set it for January 13th? Let you see what the resolution could be. What else? All right, we need to get. Plead of not guilty is entered. Mr. Potter will be shown as the attorney for the defendant. We will set a status, General Shelby, do you want to set it on, General Sylvie, do you want to set it on the 8th of September?
Yes, Your Honor. And I'll answer to either.
Sorry. Page 56, that is Timothy Tuthill. He's been previously arraigned on an indictment, but now he has a superseding indictment, and he has been booked on that superseding indictment. So that is his waiver, and I'll enter a plea of not guilty for him on this new indictment.
All right, plea of not guilty, is it set already? All right.
Judge, I mean, I'm going to ask for a new trial date, but I'm taking that you're going to say I should ask Judge Lockett Mash for that, right? Gotcha.
You are correct about that.
That's all I have. Thank you, Judge.
Safe travels. I know you were going to a graduation from law school for your daughter.
I am. We're proud. Thank you, Judge.
All right. And we have Mr. Hogan down in the basement, correct? Can we bring up, is it Michael Hogan?
Judge, should I make a quick announcement?
You may.
We've set Jamie Younger for December 11th. Mr. Younger, you're here. You understand your case is set December 11th for trial. You're good to go. Travis.
All right. We need to bring up Tyrone Hogan. They've been brought from the Department of Corrections. Mr. Wainick's case, is he still here? What about Roger Wainick? All right, so he's here, but he stepped out of the courtroom. Figured it out. That's all right. While we were waiting on that, let me see if I can pick back up on the regular docket. Mr. Wainick, we're bringing up Mr. Hogan to you. As soon as he's here, I'll take him up. But in the interim period, I'm going to try to take care of some of these folks present. On page 18, 2025 CR 256, State versus Rodrigo Flores, Mr. Baker. We lose Mr. Olin Baker. Shot collar idea is looking pretty worthy. Have a seat. I'll come back to you when your lawyer is in the courtroom. <clears throat> 2023 CR 21, State versus Amaria Kosecki Foster.
On the indictment, and they are in the conspiracy case, and I would just ask that we reset them to
September 8th.
Yes, thank you.
Thank you. All right, on page 19, 2025 CR 87, State versus Jamarian LaShawn Fikes. That's a jail case, sorry. Moving to page 20, 2023 CR 21, State versus Austin Davon Golden. Mr. Massengill.
Strowski just referenced, and I just asked that we get the status date of September 8th.
September 8th.
Thank you, Your Honor.
Final plea date is September 8th. The trial is set for October 19th through the 23rd. When you get Mr. Hogan up here, let me know unless we want to, is he here? All right, bring him out.
Judge, in this case, I was appointed to this case, and whenever I was appointed, I did let the court know, and I really can't remember which court it was, but that I had talked to co-defendant in one case, who's also the alleged victim in another case, Miss Sarah List. In preparing for trial, I went back through my notes and things and realized I had actually met with her 4 times whenever she was trying to retain me. She did not retain me, but I do feel that the information that I received from her would create an ethical conflict and would prevent me from cross-examining her in both of those cases.
Well, clearly it seems that would create a ethical violation. And the public defender's office has a conflict in this case? Mr. Locker, do you have a conflict in representing Mr. Hogan that you know of?
I don't even know what he's charged with.
Charged with aggravated assault, domestic assault by strangulation, and domestic assault with injury. And the victim is the problem, apparently.
The victim is a co-defendant in another, so that's Sarah List. That's on 2 of them. She has pled, and she is in prison. Just so the court knows, I did reach out to her to try to discuss it with her, but I haven't got anything back.
And she was in drug court. And of course, the drug court team votes on sanctions and that type of thing. I don't know that you would be able to get into that on cross-examination, but I don't think I'd even be able to try.
It's not simple. Does Mr. Lee Spratt have any conflict that you're aware of? All right, I'm going to allow Mr. Wendick to withdraw from the case. I will appoint Mr. Lee Spratt as a provisional appointment for Mr. Hogan. Mr. Spratt has a lot of experience and has tried a lot of cases in this court, and I will notify him that he's been appointed, and we'll reset the status on this case for September. All of his cases will need to be reset for status on September the 8th to allow Mr. Spratt an opportunity to familiarize himself with the case. If Mr. Spratt discovers he has a conflict, then we'll find someone else.
Judge, I know that Mr. Hogan has been transported several times, and it's a big ordeal. Can he appear by Zoom?
As far as I'm concerned, he can appear by Zoom. Since it's just a status, it would be the trial that we'll have to have him.
Sure.
All right, we'll have to set that up with the Department of Corrections, obviously. All right. (2025) CR 100, State versus Joshua Andrew Garton. Mr. Yeager. You think you'll dispose of it today?
Yes, Your Honor.
All right, so he's on the bring down. I didn't realize he was in jail. All right, we'll have him down, probably be after lunch. So.
Thank you, Your Honor.
2025 CR 111, State versus Landon Eugene Gray. Mr. Finley. Ms. Finley.
Judge, this is being handled by General Crouch. He has advised that the discovery on it is quite significant and has asked that we set it for September 8th for status.
All right, this is a first-degree murder charge and a first-degree murder by perpetration of a robbery. So September I can understand how it would be complex. So we will set it for status September the 8th. All right. Yes, sir. This is one I've already taken care of. On page 23, 2026 CR 61 State versus Marshall Dean Hagewood. Mr. Hagewood, you're here to be arraigned on an indictment charging you with violation of a protective order or condition of release. You have the right to an attorney. Do you wish to have a lawyer represent you? Are you planning to hire a lawyer?
I'll try to hire one.
All right. Then I will hand you a copy of that indictment. Do you want me to formally read that out loud in court, or do you read it yourself?
I'm ready myself.
Shall we waive the formal reading of the indictment? A plea of not guilty is entered. We will set it for status and for attorney status on September the 8th. So you will have about 4 months to try to hire yourself a lawyer. Be back here with a lawyer on that day, okay? All right, you're free to go until then.
Thank you.
2024 CR 242, State versus Ryan Hale Sr. That is a motion to sever defendants.
Yes, Your Honor, this is a case where there are two defendants, and I filed on behalf of Mr. Hale that his trial be separated, severed from the trial of the other defendant. And I think that when I spoke with General Bryson about this, she indicated that there may need to be some additional time for the state to prepare on that motion, and I've got no opposition to it being set.
Can you be ready on the 27th or the 20th or the 27th, or do you need more time than that?
Judge, we can set it on the 27th. It may resolve itself.
All right. We'll set it for May 27th for us to hear that motion or whatever resolution you reached.
Yes, sir.
All right, thank you.
Thank you, Your Honor.
Page 24, 2026 CR 46 Day versus Benny Ray Harris Sr. Mr. Harris, you're here to be arraigned on an indictment charging you with being a possession of a weapon by a convicted felon and possession of methamphetamine and possession of drug paraphernalia. You have the right to an attorney. Do you wish to have a lawyer represent you?
Yes, Your Honor.
Are you planning on hiring a lawyer?
Yes.
All right. Then I will give you a copy of that indictment. Do you wish a formal reading of that out loud in open court, or do you want to read it yourself? Shall we waive the formal reading of the indictment? A plea of not guilty is entered. We'll set it for status and for your attorney's status on September the 8th. So that's the day you got to be back with a lawyer, okay? All right, September 8th.
Thank you, Your Honor.
2026 CR 125, State versus Marvin Christopher Harris. Mr. Baker. We lost Mr. Baker at some point, so we put that on the second call. 2024 CR 129 State versus Donald Eugene Helms. That's Mr. Atchison, who Mr. Baker was standing in for.
Mr. Atchison is working on providing me with medical records, but it's my understanding that Mr. Helms has a significant medical issue, and we need to reset this if we can for a status on September 8th.
All right, September status,
Thank you.
September 8th. 2023 CR 438 State versus Lindsay Taylor Hicklin. This is Mr. Odell's case. We heard from Mr. Odell. Put it on the second call and we'll come back to this. 2024 CR 2 State
Judge,
versus.
I'm sorry. Ms. Hicklin is in custody in Missouri. So we can move her, can we put her on that January status date?
January 13th. That is 2023 CR 438 State versus Lindsay Taylor Hicklin. Now set for status January 13th of 2027. Mr. Baker is still absent from the courtroom, but we have State versus Jeffrey Ty Hicks. I'll put that on the second call. Is that to set a trial date, or where are we? I know we had a motion to suppress that I ruled on.
Judge, we have had some settlement discussions. I'll wait for Mr. Baker.
2023 CR 383 State versus Tyler Jacob Hodge. Mr. Lockard and General Bryson.
Judge, this is my motion to continue. We delayed setting this case for trial a significant amount of time because he is one of 3 co-defendants, and the other 2 co-defendants had not been picked up yet. One of those co-defendants was picked up weeks ago and has retained Miss Laura Wainick. I would like to move this trial date so that I can resolve everything together. I also became aware that the 3rd co-defendant has come in contact with law enforcement, but our extradition was only for surrounding states. So we're going to change that so that he can be extradited from the continental U.S. and maybe hopefully get the 3rd co-defendant as well.
Is this Mr. Hodges? Does he live in Kentucky?
Florida.
Florida. I had a case with a Jacob Hodge in Chancery Court the other day. I wondered if it was the same individual.
No, Your Honor.
You have any opposition to the motion to continue the trial date?
I do not, Your Honor. He's out on bond.
All right. What day do you want to set it, General?
Because Ms. Wainick has just been retained, I would like a status date in September. And she has Madison Howard, if we could give Miss Howard that same date after arraignment.
September the 23rd for status.
Okay, thank you.
And we'll just set a trial date then.
We can set a trial date then, or you want to go ahead and we'll be looking at 2027 for trial dates.
We could go ahead and get one.
Problem is that we don't have a calendar past January,
We
Mr.
we can do it
Lockard.
in September. I would request, Your Honor, Your Honor may not recall, but this defendant drove from Florida and came up during the ice storm and then came back again a couple of weeks later. And I understand why the case has to be continued, because you still got defendants that haven't
As
been
far as I'm
brought in.
concerned, he can come in on Zoom on the next status date.
That was my next question. Thank you, Your Honor.
I will allow that to take place. Ms.
Thank you.
Wainick, you represent co-defendant. All right, and we are setting this for status on September the 23rd. Ms. Wainick will be shown as the attorney for Madison Howard, and that is in That is on page 29 of the docket, 2023 CR 383, State versus Madison Marie Howard. Now is Ms. Weinig. All right,
Correct.
September 23rd.
Yes.
You have anything else, Ms. Weinig?
I was wanting to see if we would get a copy of the indictment.
All right. 2023 CR 420, State versus Terriana L. Holbrooks. Ms. Nero as the attorney. You have an attorney, Dana Nero.
Yes, she suggested that I have an attorney appointed when I talk to her.
Well, it's not necessarily her call, especially if she's identified as your lawyer, so. So when you were here on January the 7th of 2026, and it was the last day for attorney status, did Ms. Nero appear with you?
No, she had trial back in Nashville, but
And she has never filed a notice of appearance in this court.
Mhm.
All right, if you are seeking to have an attorney appointed, you will need to fill out an affidavit of your income and expenses, and we'll come back to you later in the day or tonight. That would be required that you raise your right hand and be placed under oath.
yes.
Thank you. Fill that out and hand it to one of the bailiffs. After you've done so, you'll be signing it under oath, so make sure it's accurate. 2024 CR 247, State versus Dalton Ray Hooper. Mr. Flanagan. May 27th. On page 32, 2025 CR 263, State versus Jack Edward Ingram Jr. Public defender.
Yes, sir. Mr. Ingram? Your Honor, this case is a case where it concerns events in Dickson County, and there's another case in Cheatham County concerning the same events, related events. I anticipate resolving both cases together as some kind of global settlement, and towards that, we can get the next status date. That would give us time to work on that.
State's not opposed.
All right, September 8th.
Thank you, Your Honor.
Page 33, 2026 CR 94, State versus Roy Johnson. Plea of not guilty is entered. Mr. Flanagan will be shown as the attorney of records. Status will be set September the 8th. General Sylvia, is September 8th okay? September the 8th. 2026 CR 104, State versus Aaron James Kosaric. What time do you go to bed at night? If you're talking about at the end of today's docket, right? We'll put it for the second call, but obviously, with the way things are looking, it may be a long day, so. All right. 2024 CR 236 Day versus Lacey Angelica Jordan Lackey.
That's my case. Can we second call that? We might be able to resolve that.
All right, put it on the second call. Page 36, 2020 CR 185 State versus Stephen P. Lane, Mr. Bell Myers.
Try the case or not.
Judge, this is a case that we tried and the court has granted a motion for new trial. Mr. Baker represents victim in civil case. Anyway, we would like a little bit more time to see if we cannot put all of our heads together and resolve every.
Right. This is the one that I granted a new trial based on the Christopher White, State versus
Yes.
Christopher White.
Yes, Judge.
All right. Then you want to put it on September the 8th? I'm okay if you want to have that case heard by a different judge even, so.
I don't have a problem with us, I mean, I don't know what Mr. Baker's schedule is, but I could meet and help for the May 27th one, but I don't know what Mr. Belmar's schedule is like.
I'd ask to be said as soon as possible. I mean, this is one of a handful of matters that require. I've been trying to wrap up for years.
All right, let's put it on May 27th. Mr. Baker, you surely can try to talk to your folks and give a General Wojnarowski, and we'll see whether or not they want to proceed at that point.
Thank you, Your Honor.
On page 37, 2025 CR 246, State versus Samuel Dade Lankford.
That's Mr. Atchison's case. He's filed a. We would waive reading of the indictment, enter a plea of not guilty.
Plea of not guilty is entered, set for September 8th for status. 2024 CR 146, State versus Calvin Wayne Lewis.
Your Honor.
Good morning, afternoon, and morning, whatever time it is.
As we discussed, we're going to agree to move this to September the 8th for.
September the 8th.
Thank you.
Thank you, Your Honor.
2024 CR 2, State versus Justin J. Long. Mr. Flanagan.
As this is on for status, he is still in the vote center.
November.
His completion date's in October, so if we could go to the September date, I think we can.
Let's put it on September 23rd, just to
Yes.
put it as close to his graduation date as possible. September 23rd, 2026 CR 87, State versus Roger L. Lowe. Roger Lowe.
Mr. Lowe was here. I saw him earlier. I represented him in lower court.
Mr. Lowe, you're here to be arraigned on a charge of aggravated assault. You have the right to an attorney. Do you wish to have a lawyer represent you?
Well, Your Honor, I'm not sure yet. I don't know how circuit court works. I've never been here. Do I get like a chance to talk to the DA before? I don't want to get in the middle of this and say I didn't want a lawyer and not be able to hire one later. I mean, I don't really know how this works.
You have the right, what I normally will do is if you want to either talk to the district attorney and then try to hire a lawyer, I'm going to give you 4 months to do that. And that would be setting your case for status on September the 8th. And you can talk with the district attorney by making an appointment to come in and talk with them. And you understand that I don't have to give you legal advice, that they represent the state of Tennessee.
Yes, sir.
So while they may talk with you about your case, any statement that you make to a district attorney when you're in those discussions that might implicate you could be used against you in a court of law. Do you understand that?
Yes, sir, I'm aware of it.
Then I will move your case to, well, first of all, you're being arraigned. Do you want me to formally read this out loud to you, or can you read it yourself?
I can read it myself, or you can read it out loud, don't matter to me.
In the Circuit Court for Dickson County, Tennessee at Charlotte, May term Grand Jury 2026. Grand jurors of Dickson County, Tennessee, duly impaneled and sworn, upon the oath do present that on or about December the 26th, 2025 in Dickson County, Tennessee, and prior to the finding of this indictment, Roger L. Lowe II, then and there, did unlawfully, feloniously, and knowingly commit an assault as defined in TCA 39-13-101 while displaying a deadly weapon, to wit, a pistol, thereby causing the said William Quillen to reasonably fear imminent bodily injury in violation of TCA 39-13-102, a Class C felony, all of which is against the peace and dignity of the state of Tennessee. W. Ray Crouch, as the District Attorney General.
How would I go about setting that appointment with the DA's office? Just calling them and?
I want you to real subtly turn around and look at the table behind you. They're the ones that, I'm giving you a new court date. This is the date that you will have to be back here and hire a lawyer if you're going to hire one, or try to resolve your case if you don't hire one.
Yes, sir.
September the 8th. I'm sorry, give me that back. I said September the 23rd. No, I didn't. I said September. That's fine. Okay, September the 8th.
So we'll be back here September the 8th.
September 8th.
Thank you, sir.
2024 CR 67, State of Tennessee versus Charles McDonald.
Can we get the September 23rd status date?
September 23rd.
Thank you, Judge.
2021 CR 100, State versus Jacob Dakota Miles.
Your Honor, Mr. Miles is present. This is a case with General McEllier. He's not yet here. If we could second call it, that would
Put it
be.
on the second call.
Thank you, Your Honor.
2025 CR 110, State versus Jeremy Cole Mulholland. Raise your right hand, Mr. Mulholland.
I do.
You have filled out an affidavit of indigency, and I'm looking at it. You make $500 a week at Whataburger, is that correct?
That is correct.
And then you have real property that you don't have an interest in, but it's my understanding it has a mortgage against it that is in excess or actually almost as much as it's worth. Is that correct?
That is correct.
And you have no other means of hiring, of coming up with the money to hire a lawyer, and you have 4 dependents?
That is correct.
All right, I find this defendant to be partially indigent in order that he pay a administrative fee of $250. I will appoint the public defender to represent you, Mr. Mulholland.
Your Honor, I acknowledge receiving a copy of this violation warrant, waive formal reading of the same, and enter a plea of not guilty on behalf of the defendant.
All right, Set it for May 27th. All right. You want to do it in June? June 29th, is that what it was? June 17th,
June 17th,
yes. June 29th,
June 29th.
thank
My
you.
assistant will give you a card.
2026 CR 63, State versus Nicholas Lee Murphy. Nicholas Lee Murphy for arraignment. Do we have a bond on Mr. Murphy? Those OR bonds are incredibly effective. So the conditional forfeiture of his OR bond, capias for the defendant, new bond will be $5,000, cash or commercial only. (2026) CR 93, State versus Victoria D. Myatt.
Afternoon, Your Honor.
It
Hannah
is the
Shanley on
afternoon.
behalf of Ms. Myatt, who is also here. Your Honor, I would acknowledge receipt of the indictment in this case, waive formal reading, and enter a plea of not guilty on behalf of Ms. Myatt. And we would just ask that this be set for the status date on September 8th.
All right, September 8th for status.
Thank you, Your Honor.
Thank you. Do you have a card that you can give the clerk? Pardon me. 2024 CR 52, State versus Jordan William Neely.
This is set for a status today. General Wojnarowski and I have been discussing discovery. This is a case that originally there's an investigation out of Davidson County, Your Honor. A lot of the information in the case, including the discovery, comes from Davidson County. We're talking about, the general and I are talking about getting additional information from Davidson County, search warrant information. So if we could get the next status date, that's what I would ask for.
Is September going to be long enough away? You want to set it on that September 23rd date, criminal docket, September 23rd.
And I'll tentatively put my motion in limine on the same day.
Yeah, let's
if
do
that
that.
makes sense.
Because I don't show, the docket didn't show a motion in limine, but if you file one or if you've already filed one, we'll hear it on that day.
Yes, sir. Thank you.
Thank you. Moving to page 45, 2026 CR 96, State versus Patrick Peters. Patrick Peters for arraignment. Mr. Peters have a bond. It would be a conditional forfeiture of the bond in the amount of $3,000, Sarah Facier, the bonding company. Set it for, let's see. This 6 months would be, set it for the December docket call. Final forfeiture will be set for December the 3rd. Capias for the defendant. New bond will be $10,000. Do I want you to what? No, because it was a OR bond, so I don't have to worry about a Sarah Facia. 2022 CR 402, State versus Charles Bo Pruitt. I'm sorry, he's in jail. We'll move on. 2026 CR 107, State versus Ammon Travis Puckett.
Up this morning after we told him not to, but he was nervous. So we'll waive formal reading and enter a plea of not guilty.
Plea of not guilty is entered. Status day of September the 8th. 2024 CR 109, State versus Ethan Pulley. Mr. Locker.
Yes, Your Honor. He came up before when we called the other daycare defendants.
Oh, that's right. I'm sorry. Yes. Okay, we've already dealt with him on the record.
Yes, Your Honor.
Thank you. Moving to page 48, 2025 CR 176, State versus Eddie Jorge Torres Rojo. Mr. Ladner. Pardon? Okay. Is Mr. Ladner still here?
No, Judge, Mr. Flanagan, were you going to stand in?
Because I got a text from Mr. Ladner, case is on just to get a new date.
So we're just setting a new status date,
Yes, Judge.
September 8th. Twenty 25 CR 253, State versus Jacoby Deshawn Sanders.
Thank you, Your Honor. That's for plea. Your Honor, this is Mr. Sanders. He is, subject to the court's approval, going to resolve his case today. The terms of that are that he will plead no contest to count one, possession of Schedule 6 with intent. It's a Class E felony. The punishment on that will be 2 years TDOC at range 1, but it is suspended to supervised probation. He'll have monthly drug screens with zero tolerance for positive screens and in-person reporting only. He'll have a $2,000 fine. He'll have to forfeit the seized weapon and all other items that were seized. For count 4, he's going to plead no contest to driving while a license was revoked, second or subsequent. It's a Class A misdemeanor. The punishment will be 11 months, 29 days, Dickson County Jail, at 75% release eligibility. That is also suspended to supervised probation, and that sentence is concurrent to the sentence in count 1. He'll have to pay the court costs. Counts 2 and 3 of this indictment will be dismissed in settlement, and he'll be credited with pretrial jail credits listed on this plea sheet. So I'm having Mr. Sanders sign where it says defendant here, okay? And put the date there. It's May 13th. Mr. Sanders.
Mr. Sanders, raise your right hand. Let's place you under oath.
Yes.
State your full name for the record.
Jacoby Deshawn Sanders.
Thank you. You can put your hand down now. Mr. Sanders, you're here today on a multi-count indictment. You've heard your lawyer go over what you're pleading to. That 2 of the counts and 2 of them are being dismissed. But have you seen or been shown a copy of the charges? Talked them over with Mr. Talbot and discussed with him the range of punishment you're facing as well as any possible defenses you might have to the state's evidence.
Yes, sir.
You feel like you understand what you're charged with?
Yes, sir.
Do you understand that you have a right to plead not guilty and have a speedy and public trial by jury in this court?
Yes, sir.
You understand you would have the right to have a lawyer and have one appointed if you cannot afford your own?
Yes, sir.
Do you understand that if you went to trial, you would be presumed to be innocent? And until such time as the state proved your guilt beyond a reasonable doubt to the satisfaction of all 12 jurors, and their verdict would have to be unanimous before you could be convicted of anything.
Yes, sir.
You understand at trial, you and Mr. Talbot could confront and cross-examine all witnesses the state called, and you can bring in your own witnesses by the use of a subpoena.
Sir.
You understand that at trial, you're presumed to be innocent. You would not have to testify or prove anything, and no inference of guilt would arise because you did not testify at your own trial.
Yes, sir.
You understand if you went to trial and you were found guilty, you could appeal that conviction and the sentence imposed to the Court of Criminal Appeals, and have a lawyer appointed to help you with that appeal.
Yes, sir.
You understand that by pleading guilty, you are pleading no contest. You're waiving your right to a trial and to an appeal. All I'm going to do is approve what your lawyer has worked out with the state.
Yes, sir.
You understand that a plea of no contest means you're not going to admit you did anything wrong, but you're not going to contest the state's evidence. And as a result, the state will tell me what their evidence would be at trial, and I will use that evidence to find you guilty.
Yes, sir.
Do you understand everything I've explained to you?
Yes, sir.
Do you understand that by pleading no contest, you're waiving your right to a trial and to an appeal, and that's going to result in two convictions that will be on your record in the future to make more severe the punishment you receive if you're ever again convicted of a crime. Do you understand everything?
Yes, sir.
Is your decision to plead no contest today voluntary?
Yes, sir.
Anybody forcing you to do this
No, sir.
against your will? Do you understand I can't accept your plea unless I'm satisfied there is a factual basis for it and that you are in fact guilty?
Yes, sir.
Then listen as the state tells me what their evidence would be if you went to trial.
Your Honor, in this case, if the state had gone to trial, the state would show that on July the 14th of 2025, Mr. Sanders was stopped by Trooper Griffin with the Tennessee Highway Patrol due to the fact that he was speeding at 89 miles an hour on the interstate here in Dickson County. During the stop, it was determined that Mr. Sanders had a revoked driver's license. Also, there was a smell of marijuana coming from the vehicle. A probable cause search was conducted. Approximately half a pound of marijuana was located in the trunk of his vehicle, and Mr. Sanders ultimately admitted that he was selling that marijuana.
All right, I'm not asking that you agree with those facts, but do you understand that's what the state's evidence would be if this case went to trial?
Yes, sir.
You still wish to plead no contest?
Yes, sir.
Are you satisfied with your attorney's services? You feel like that Mr. Talbot's done a good job of representing you competently?
Yes, sir.
Mr. Talbot, do you know of any reason he should not enter this plea?
No, sir.
Anything further from the state? Then Jacoby D. Sanders in docket number 2025 CR 2253, upon your plea of no contest to count one, I find you guilty, sentence you to 2 years Tennessee Department of Corrections as a range 1 offender that will be suspended to supervised probation with monthly drug screens with zero tolerance for positive drug screens and in-person reporting only. You ordered to pay a $2,000 fine. The weapon that was seized is forfeited, and all other items that were seized are forfeited. In count 4, you're found guilty of driving while your license is revoked. A second offense, you're sentenced to 11 months and 29 days in the county jail, suspended to supervised probation. That will serve concurrently with count 1. Your order to pay the court costs. Counts 2 and 3 are dismissed as part of this agreement. That's the judgment of the court. He needs to see the probation department. All right, we're going to break for lunch. We'll be at lunch recess until 1:30.
All rise.
I don't know where I stopped. Let me, I think where we are now is on page 48. 2025 CR 40, State of Tennessee versus Deanna Elise Selke. That's Mr. Atchison. I'm sorry.
Settle that for Mr. Atchison, Judge.
So by saying that, are you asking me to pass it until later
Yeah,
tonight?
Yeah, if you give me a second call on that, maybe I'll have a plea on that, hopefully,
All right.
or a disposition, or
2024 CR 180, State versus Gary Lee Shadow Jr. is in jail. 2023 CR 420, State versus Rondell Newsom Shelton. I show that Mr. Shelton, is your lawyer, is Aaron Coleman.
Yes, sir. She had a trial or something. I just tried to call her. I was just outside, so I don't know if she called or what.
This is a conspiracy count. Is this the one that's already set? Rondell Newsom Shelton. September 8th. September 8th. Stay in touch with your lawyer. Be back September 8th.
Yes, sir.
2025 CR 103, State versus Jamie Allen Stewart, Public Defender.
There's a settlement offer. May we please second call this? I would like to discuss the settlement offer with Mr.
Put
Stewart.
it on the second call. 2025 CR 189, State versus William Franklin Stout III, Mr. Finley's case.
Like to get another status date, Your Honor.
State have any opposition to another status date? William Franklin Stout III. Let's put it on the 23rd. September 23rd for the last, that'll probably be the final status or plea day that we'll have to set up for trial thereafter.
Mr. Finley's telling me he's having problems he does not have discovery. I guess the website is not working for him, so I'll have him work on
Okay.
that. I know he's requested a password reset, but I think
May
that's
want to get
been,
somebody more technologically advanced to be able to help him with it.
perhaps I'll help him.
All
Your
right.
Honor, I have one other case. Would you like me to wait until
No,
you
go
call?
ahead. What is it?
It is, let's see, Jamaron L. Frakes,
Last name?
F-Y-K-E-S. Fikes, oh, okay, I thought it was Frakes, I'm sorry. Yeah,
She
I
is
thought
in
it was in jail.
jail. What are we doing with her?
He needs another status if we could have that, Your Honor.
September 23rd.
Thank you, Judge.
All right, thank you. On page 52, 2026 CR 88, State versus Stephen Wilson Swope. That was Mr. Potter's case, and I know he left early. General Sylvia, do you know what the agreement, what the discussions were about Mr. Swope?
Yeah, we set it on September 8th, sorry, 2026 for plea and status.
All right, the new status is September 8th. 2024 CR 136, State versus Billy Wayne Thomas. This was shown to be the final status date. Are we setting it for trial? All right, do you want to put it on the September 23rd date? Status date is September 23rd. Step in front of the microphone if you will, please.
Cynthia Sherwood was representing Mr. Thomas and withdrew, which the court granted, I believe, in January of this year, and set Mr. Thomas on Judge Lockhart Mash's docket to obtain new counsel in March. I filed my notice and appeared at that date, and we received this date. So it's my first appearance before Your Honor on the case.
That's fine.
But I understand it's been said a few times.
Well, we have you down now, so.
Thank you so much.
All right. (2023) CR 391, Anthony Nathaniel Thompson. Set for trial tomorrow.
Yes, Judge, it's ready for trial and there are no contested motions.
All right, trial at 9 o'clock tomorrow morning. Jury selection will begin. Is Mr. Webb still here? Okay. 2021 CR 304, State versus Casey Noah Thompson. All right, this is here today because apparently you have been successful in your completion of the community corrections portion of your sentence. And it's been requested that you be transferred back to regular probation. So I will grant that request and transfer you back to probation. And remember, the sentence isn't over, but it's just that you've been successful in the first part. I hope you'll be successful in this part. So make sure you know who your probation officer is that you got to deal with.
Yes, sir.
All right, thank you. Good luck to you. (2023) CR 438, State versus Eric Matthew Weekly. For status, public defender is his lawyer.
Judge, we believe Mr. Weekly is deceased. We have been unable to obtain significant documentation of that, but I've been in contact with prosecutor's office over in Missouri where he was charged with subsequent charges. They have dismissed his charges because they believe him to be deceased, and so the state will enter a nollie.
All right, case is dismissed upon the death of the defendant. 2025 CR 2023 CR 244, State versus Darzell T. Wester, public defender.
Judge, Mr. Wester is in custody out of state, and we are just tracking this case to see if he's been released. So if we could put it on that January status date.
January 13th, 2027. (2026) CR 68, State versus Jana Celeste Wheeler. Ms. Wheeler, you're here to be arraigned on an indictment. 2026 CR 68 charges you with Schedule I drugs, possession with intent to deliver or sell, and count 2 is possession of drug paraphernalia. Then you also have indictment number 2026 CR 69 charging you with possession of methamphetamine with intent to sell 0.5 grams or more. You have the right to an attorney. Do you wish to have a lawyer represent you?
I do.
You filled out an affidavit. If you'll raise your right hand, let's place you under oath.
I do.
Ms. Wheeler, I need you to sign this document. By signing it, you're affirming under oath that all of these information on this is true and correct.
Yes, sir.
Now, it shows you have no income. How are you able to live if you have no income?
I actually had to leave treatment. I was offered a 3-month extension as a peer there, but I completed 30 days of that, and I have a program that I am currently waiting on my phone call tomorrow morning to go into that's a year-long program. So that is why I have no income right now.
All right. Well, I do find that she is indigent, therefore I will appoint the public defender to represent her.
Your Honor, I acknowledge receiving a copy of the indictment and waive formal reading of the same, and enter a plea of not guilty on behalf of the defendant.
Plea of not guilty is entered. Status day will be set for September the 23rd.
Yes, sir.
On page 59, 2026 CR 127, State versus Raven, Victoria Young. Ms. Young, you are here today to be arraigned on an indictment charging you with 2 counts of being a parent or custodian knowingly allowing your child of 8 years or younger to be exposed to a sexual offender. You have, in a failure to protect charge, you have the right to an attorney. Do you wish to have a lawyer represent you? Are you able to hire a lawyer? Raise your right hand. Let's place you under oath. We're going to give you a form to fill out that's called an affidavit of income and expense. Oh, you've already filled it out? All right, thank you. Is all of the information in your form true and correct?
Yes.
You're not working anywhere?
No.
Have no income?
No.
I would ask you the same question I asked the prior lady. How are you able to live if you have no job or
My
income?
dad is helping me right now with everything until I can get my social security disability.
All right, I do find that she is indigent, and therefore I will appoint the public defender to represent her. All right, I will appoint Ms. Kelly Jackson Smith to represent her. Ms. Kelly Jackson Smith was here earlier, but she completed her business and left. So I will need to notify her of that. Standing in for Ms. Smith, may I see that indictment again? This is in the Circuit Court for Dickson County, Tennessee, the May term grand jury 2026. Grand jurors of Dickson County, Tennessee, duly impaneled and sworn upon their oaths do present. In honor about February the 12th, 2026 in Dickson County, Tennessee, and prior to the finding of this indictment, Raven Victoria Young, then and there being a parent or guardian of children under 18 years of age, did unlawfully and knowingly allow children to be under the care or supervision of a person who is an offender as defined in section 4039-202 and required to register pursuant to Title 40, Chapter 39, Part 2, or allows children to be unaccompanied with a person who is required to register as a sexual offender pursuant to Title 40, Chapter 39, Part 2, to wit, AL, in violation of TCA 3915-401, C2, a Class A misdemeanor against the peace and dignity of the state of Tennessee. Count 2, the grand jurors aforesaid upon their oaths aforesaid do further present and say that on or about February the 12th, 2026, and prior to the finding of this indictment, in the county and state aforesaid, the said Raven Victoria Young, then and there being a parent or guardian of children under 18 years of age, did unlawfully and knowingly allow children to be under the care and supervision of a person who is an offender as defined in Section 4039-202 and required to register pursuant to Title 4039, Part 2, or allows children to be unaccompanied with a person who is required to register as a sexual offender pursuant to Title 40, Chapter 39, Part 2, to wit, HL, in violation of TCA 3915-401C2, a Class A misdemeanor, and against the peace and dignity of the state of Tennessee, signed W.A. Crouch, District Attorney General. I am giving you the name of your attorney, Ms. Kelly Jackson Smith. That's on the top of that indictment. Will show that you've been arraigned. I'm going to set you for a status on September the 8th of 2026. Be back on that day. It'll be up to you to contact Ms. Smith. Her office is in Dickson, Kelly Jackson Smith. If you'll contact her and set up an appointment and take that with you, okay? All right, thank you. (2023) CR 406, State versus Jamie Lee Roy Younger, and that's the case that we set on December the 11th, if I understand correctly. (2023) CR 273, State versus Thomas Adam Zurowek. Mr. Flanagan.
For disposition, he has a pending case that's set for trial. He's going to plead on that. He's picked up a new charge, same offense, and we're going to proceed by information on that. He'll plead on that.
Part of this agreement, I know you need to use this area, but we could
So what am I doing today?
Well,
Go.
I suggest that first of all, sign the plea forms. Everyone wants him under oath admitting that he is guilty of both, prepared to do that. Just not going to enter the judgments or not enter the plea.
All right. Mr. Zurowek, raise your right hand. Let's place you under oath. Thank you. State your full name for the record.
Tomasz Adam Zurowek.
Mr. Zurowek, you are here today charged with one indictment, and then I've been handed something called a criminal information, and I want to go over your rights regarding the criminal information so that you fully understand. Under our Constitution, every person who is charged with a criminal offense that carries the possibility of incarceration has the right to have those charges reviewed by, and the evidence reviewed by, an independent body called the grand jury of that county. The grand jury operates in secret, and they review evidence, only one side of the evidence, but they review the evidence, and they make a determination as to whether or not there is sufficient probable cause to return a charge against an individual. If they do, it would be a true bill. If they find there's not sufficient evidence, then it would be a no true bill. And that would then result in an indictment or a presentment that would be brought into circuit court, and you would then be prosecuted on that. Every person also has a right. Ask this lady to quit sticking her arms up in the back, please. You also have the right to waive that step in order to expedite the disposition of this case. If you do that, then you need to understand that it would be treated the same as if you've gone through the grand jury process, but you will be skipping that step. Do you understand all of that? You understand you have an absolute right to have them review the evidence, but you have a right also to waive it. So is that what you wish to do?
Yes, sir.
All right. Then in each of these cases that are now before the court, and I believe he's already signed that, In each of these cases that are now before the court, do you understand what you're charged with, and have you and Mr. Flanagan had a chance to talk them over and discuss the range of punishment you're facing as well as any possible defenses you might have?
Yes.
While it's indicated that you want to enter a plea of guilty to both of these charges, you understand you have a right to plead not guilty and to have a speedy and public trial by jury on all charges.
I do understand.
You understand that you would have the right to have a lawyer and to have one appointed if you could not afford your own lawyer.
I do have a lawyer.
But you understand you would have the right, absolute right to a lawyer. Do you understand that if you went to trial, you would be presumed to be innocent until such time, if ever, the state proves your guilt beyond a reasonable doubt to the satisfaction of all 12 jurors, and their verdict would have to be unanimous before you could be convicted of anything? Do you understand that? Do you understand that if you went to trial, you would be able to confront and cross-examine every witness the state called to testify against you, and you can bring in every witness that you want by using a subpoena? You understand at trial you would be presumed to be innocent until such time, if ever, the state proves your guilt beyond a reasonable doubt to the satisfaction of all 12 jurors, and their verdict would have to be unanimous before you could be convicted of anything.
I understand.
You understand that if you went to trial and you were found guilty, you could appeal that conviction and the sentence imposed to the Court of Criminal Appeals and have a lawyer appointed to help you with that appeal.
I understand.
And you understand you'd be presumed to be innocent, you wouldn't have to testify or prove anything. You understand all that?
Yes.
You understand that by entering these pleas of guilty, you are waiving your right to a trial and to an appeal. All I'm going to do is approve what your lawyers have worked out with the state. You understand
Yes, I do.
that? But do you understand that that's going to be resulting in convictions that will be on your record in the future to make more severe the punishment you receive if you are ever again convicted of a crime?
I understand.
Now, I've been handed a document called a Notice of DUI Punishment that sets forth all of the statutory requirements and provisions regarding the enhancement. In other words, that every conviction that you have makes the next conviction more severe, the punishment more severe. And it bears your signature. Is that your signature?
That is correct.
And did you go over this with Mr. Flanagan? Do you feel like you fully understand that?
Yes, sir.
All right. Then, do you understand everything I've explained to you so far?
Yes.
Do you want to waive your right to a trial and to an appeal by entering a plea of guilty?
Yes, sir.
Is your decision to plead guilty today voluntary?
Yes.
Anybody forcing you to do this against your will?
No.
Do you understand that I can't accept your plea? Well, first of all, you understand if you plead guilty, the court of the state could ask you questions about this offense. And if you answer those questions under oath, on the record and in the presence of your lawyer, your answers could later be used against you in a prosecution for perjury if I determine you were lying under oath.
I understand.
Right. You understand I cannot accept your plea unless I'm satisfied that you are guilty and that there are facts to support it.
Yes.
All right. Then, General, do you want to ask the questions that you feel like needs to be on the record?
Dr. Zerwick, were you involved in a car crash on March 31st, 2022?
Yes.
And that was a crash that occurred driving where you struck, I believe, a delivery driver at the intersection of Highway 46 and Beasley Drive in Dickson.
Yes.
And at that point, you were under the influence of alcohol.
Yes.
Okay, I believe you were 6'2" according to TBI. Does that sound correct?
Yes.
And then on May the 7th of this year, you were found at Lake Circle Drive after driving and having multiple glasses of wine. Is that correct?
Yes. Yes.
Okay,
Yes.
and you believe that you wrongfully thought that was your house, correct?
That's correct. Yes.
Turns out it was not, correct?
That's correct.
Due to the impairment of the alcohol.
Yes.
All right. Then at this point in time, I will ask you, are you satisfied with your attorney's services?
Yes, I am.
You feel like Mr. Flanagan's done a good job of representing you competently?
Yes.
Mr. Flanagan, do you know of any reason he should not enter these pleas?
No, Your Honor.
Then I will suspend the sentencing here, or suspend this portion of this case until the 27th, and we will come back on the 27th of May and finish the disposition and sentencing in this case.
Just for the record, we will be moving a motion to revoke
All right. Then we will set it for May 27th. All right, we've been through the docket once, all 59 pages, I'm going to go back through the second call, and then we'll take the jail cases. Do we have inmates up here? All right. Let me run through these second calls, and then we'll take the inmates up. 2026 CR 90 State versus Nicholas Adam Butler. Mr. Butler, you were previously placed under oath, and you've indicated that you have no income. Is all of that information on this form true and correct?
Yes, sir.
Your bond was made by your mother?
Yes, sir.
All right, I find Mr. Butler to be indigent, and I will appoint the public defender to represent him. He was here for arraignment on a charge of evading arrest by flight by vehicle. So,
Acknowledge receipt of the indictment, waive formal reading, enter plea of not guilty at this time.
plea of not guilty is entered, set for status September the 8th. Twenty 2025 CR 256 State versus Rodrigo Flores. Mr. Baker.
Need to talk to him about because it's got a jail component and substantial restitution. Can we move that to the September date?
Well, September, or
Put it on VOP of this day, put it in the email with him. We could do a VOP status date, see if we can resolve this.
May 27th.
May 27th? Sounds good, Judge.
On page 20, 2025 CR 100, State versus Joshua Andrew Garton is in jail. But that's going to be for disposition, you said. Do we have Mr. Garton here? Let's go ahead and bring him out. Mr. Baker, the second call on one of your cases, you were out of the courtroom. State versus Marvin Christopher Harris. You've already filed a waiver of arraignment. All right, then do we want to set it for, I assume we just set it for September the 8th? All right, thank you. Well, my granddaughter goes to that church, to that school, so probably need to put that on somebody else's. Why don't we move that, Mr. Harris? Let's just move it to your, let's put it on Judge Turnbow's docket next. That would be in August. I'd say August, it's a VOP, is that correct? No, it's a violation. Let's put it on August 3rd. All right, Mr. Yeager, I'm sorry, were we ready on Mr. Garton?
Yes, Your Honor.
All right, I've been handed a document indicating that Mr. Garton is prepared to enter a plea to counts 1 through 5 of this indictment, which will all be amended to a violation of Tennessee Code Annotated 3913-527, sexual battery by an authority figure, and receive a sentence of 4 years, split confinement to serve 1 year day for day, with credit for time served, then released to state probation for a period of 3 years. He would be required to have in-person reporting, undergo a psychosexual evaluation, and follow the treatment recommendations, have no contact with the victim, BB, and he would be on the sex offender registry as required by law. This would be concurrent with 2019 CR 155. Remaining charges would be dismissed. Mr. Garton, raise your right hand. Let's place you under oath.
Yes.
All right, state your full name for the record, please.
Joshua Andrew Garton.
Mr. Garton, you're here today on a multi-count indictment. You've heard me go over what the agreement is, but have you seen or been shown a copy of all your charges and talked them over with Mr. Yeager? You and he discussed the range of punishments you're facing as well as possible defenses you might have.
Yes.
Well, it's indicated that you want to enter this plea of nolo contendere. What that means is you're not going to admit you did anything wrong, but you're not going to contest the state's evidence when they tell me what their evidence would be at trial. And I'm going to use that evidence to find you guilty according to this agreement. Do you understand that?
Yes.
You also understand you have a right to plead not guilty to all charges and have a speedy and public trial by jury in this court.
Yes.
You understand if you went to trial, you'd have the right to have a lawyer and have one appointed if you could not afford your own.
Yes.
You understand that if you went to trial, you would be presumed to be innocent until such time, if ever the state proved your guilt beyond a reasonable doubt to the satisfaction of all 12 jurors, and their verdict will have to be unanimous before you could be convicted of anything.
Yes.
You understand that if you went to trial, you and Mr. Yeager could confront and cross-examine every witness the state called to testify, and you could bring in your own witnesses by the use of a subpoena.
Yes.
You understand you would be presumed to be innocent. You would not have to testify or prove anything, and no inference of guilt would arise because you did not testify at your own trial.
Yes.
You understand if you went to trial and you were found guilty, you could appeal the conviction and the sentence imposed to the Court of Criminal Appeals, have a lawyer appointed to help you with that appeal.
Yes.
Do you understand that by entering this plea of no contest, you're waiving your right to a trial and to an appeal? All I'm going to do is approve what your lawyer and the state have agreed upon.
Yes.
You understand that that is going to result in multiple convictions, and those convictions are going to be on your record in the future to make more severe the punishment you'll receive if you are ever again convicted of a crime.
Yes.
Do you understand everything I've explained to you?
Yes.
Do you want to waive your right to a trial and to an appeal and enter this plea according to this agreement?
Yes.
Is your decision to plead guilty today, no contest today voluntary?
Yes.
Anybody forcing you to do this against your will?
No.
You understand I cannot accept your plea unless I'm satisfied there is a factual basis for it and that you are in fact guilty.
Yes.
And I want you to listen as the state tells me what their evidence would be if this case went to trial.
Yes.
General?
Judge, if this case were to proceed to trial, the proof would show that between January 1st, 2018 and December 31st, 2019, the defendant touched victim BB, who was between the ages of 6 and 7 years old at the time, on her vagina for his own sexual gratification, at least on 5 different occasions. He held a position of trust and used said position of trust to accomplish these acts. This was disclosed in a forensic interview years later. Witness testimony from family and friends would attest to the opportunity that the defendant would have had to commit these acts. Mother of BB and defendant's girlfriend at the time would often leave BB at home alone with the defendant while they would walk to Walmart. Victim was able to identify pictures of the defendant's residence where these incidents took place. Apartment records were obtained by law enforcement to corroborate that the defendant lived at Beasley Point Apartments located here in Dickson County, and were several of these pictures that the victim BB was able to identify.
All right, Mr. Gordon, I'm not asking you to agree with those facts, but do you understand that's what the state's evidence would be if you went to trial?
Yes.
You still wish to plead no contest?
Yes.
Are you satisfied with your attorney's services?
Yes, I actually.
Do you feel like Mr. Yeager's done a good job of representing you competently?
He's done excellent.
Mr. Yeager, do you know of any reason he should not enter this plea?
No, Your Honor.
Anything further from the state?
Judge, just for the record's purpose, the state has had in-depth conversations with mother, father, well, what they considered a grandparent of child BB. I've also had discussions with BB concerning the proof in this case, likelihood outcomes at trial, and this was this settlement was signed off on by mother, grandparent, and BB.
All right, then Joshua Andrew Garton in docket number 2025 CR 100, upon your plea of no contest to counts 1 through 5, in each of those counts, you are sentenced to 4 years in Tennessee Department of Corrections. In each of those counts, that 4-year sentence will be served on a split confinement to serve 1 year day for day, and then be released to state probation with credit for time served. The remaining 3 years of your sentence would be served in each case on probation. You are to undergo a psychosexual evaluation and follow the treatment recommendations. And there'll be no contact with the victim BB. You'll be on the sex offender registry as required by law. And then this will be concurrent with 2019 CR 155. The only question that's not yet been, it doesn't specifically state, and maybe I've missed it, are these 5 counts all served concurrently with one another?
Yes, Your Honor, they are.
And I'm going to make that notation. So. All right, that's the judgment of the court.
Thank you, Your Honor.
Mr. Baker on State versus Jeffrey Ty Hicks.
How to resolve that one today?
And that's today.
We're going to try. And Judge, also if I can address the court, I submitted Ms. Selke's TBI indigency form to run a diversion application. The court would be inclined to sign that for me. I'll send that off and I'll see if we might resolve that case today. Mr. Atchison, have any other cases you need to resolve?
I don't know, but if you want me to sign something, you're going to have to lay hands on it and hand it to me. I'm a little busy, so. 2023 CR 420 State versus Terriana L. Holbrooks. Ms. Holbrooks, you have filled out this affidavit and you were placed under oath earlier. Is that all of that information true and correct?
Yes, sir.
You have no income. How were you ever planning to hire a lawyer?
My mom and my granddad was gonna help.
All right. I find that she is indigent and therefore is entitled to have a counsel appointed. Public defender. Maybe you should just read me the list of people who don't have a conflict of interest. Does Mr. Roger Wanick and the Wanick Law Firm have a conflict? All right. I'm going to appoint Mr. Eric Locker of the Cheatham County Bar to represent this defendant. You have, has she already been arraigned? She has. This is status for attorney status only. Mr. Eric Locker is a member of the Locker Law Firm over in Ashland City. It'll be your responsibility to contact him and make an appointment to go in and see him. And in the meantime, Have we set a status day on these cases that are conspiracy? September 8th is your next court date, so you need to make sure you go as quickly as possible to meet Mr. Lockhart so he can start working on your case, because September the 8th, we may be setting you a trial date. Okay? Thank you. Twenty 2026 CR 104, State versus Aaron James Kosurik. Mr. Winnick. 2024 CR 236, State versus Lacey Angelica Jordan Lackey. Mr. Baker.
I have just written up a plea sheet on her. We received her diversion back, and if you could second call that, or I guess third call that, we should have something.
Excuse me. 2021 CR 100, State versus Jacob Dakota Miles. Public defender asked for a second call.
On Mr. Miles's case, may we please go to the status date in September?
Let's do September 23rd, trying to spread out these
Yes, sir.
cases. September 23rd.
Thank you, Your Honor. All right.
And is Mr. Baker? State versus Jamie Allen Stewart, public defender.
One more time, we're about to get this done, but we just need a couple.
All right. All right, then we're ready to take up those inmates that we have here. Just bring out the first inmate. You have males or females? All right. All right. We're gonna have to deal with it sooner or later, so we might as well deal with it. So stay ready on Mr. Adams's bond motion. All right. Can you tell me what the present amount of the bond is? I've seen what looks to be 10,000, 12,000, 12,000. Okay, all right. Then I'm ready to hear whatever proof you wish to offer. Adams, you'll come around here. Mr. Adams, this way. We're going to put you in that witness stand. Mr. Adams, I need you to stand and raise your right hand and be placed under oath.
Yes, I do.
Good afternoon, Mr. Adams.
How you doing?
Doing all right. So where is it that you reside when you're not incarcerated, Mr. Adams?
1190 Bell Hollow Road,
And-
Van Leer, Tennessee.
And that's located here in Dickson County, correct?
Yes, sir.
And how long have you been residing there?
I've been there approximately 5 years, but I've been in Dickson for 63 and a half years.
Okay. And that property in Van Leer, do you rent or own that property?
I completely own it, yes.
Okay. And when you aren't incarcerated, what do you do for employment?
I am a carpenter.
Okay. And who do you work for?
I work for well, I'll be going back to work for the guy that does the AA meetings in the jail, Gene.
And so if you were released, your bond was reduced or you were granted an OR bond, you could go to work immediately.
Absolutely.
Okay. And this isn't your first interaction with the court system,
No,
is
sir,
that
it's
fair to
not.
say? Okay, have you previously been granted an on recognizance bond or a?
Yes, sir. Yes, sir.
When was that?
I think it was 2023, I think.
Okay. Are there any instances where you have failed to appear at a court date?
Never. I've came to every court date.
Do you have any reason to leave Dickson County?
No,
until this
sir.
is resolved?
No, sir. I have no family. My wife passed. I'm here,
Okay.
for the rest of my life.
Do you have any other matters that are currently pending disposition or appeal at this time?
No, sir.
It's the only case you have open?
Yes, sir.
Okay. So you're charged with aggravated burglary, theft, vandalism, and I'm maybe missing, I think it might have been a criminal trespass.
Yes.
Do you anticipate a prison sentence being,
No, because I'm definitely gonna,
have you previously been on probation?
yes, sir.
Do you think you can succeed at probation?
Oh, yes, sir.
Okay. You're not concerned about possibly going to prison? That would not be a factor that would make you not appear?
No, I'm not concerned about going to prison.
Okay. What, if any, substance issues or mental health issues do you have that might be better addressed outside the jail?
Well, I wanted to go to rehab for a while because I was drinking a lot. And I've got, I've got some unfinished business I need to take care of before I do that. And then my prior plans are to go to rehab and do a year program.
How long have you been drinking?
Well, I'm 63 and a half, so probably since I was 18.
Okay. And you think now that we've had some serious consequences, it might be time to address that?
Yes, sir. I really do think it's what I need to do.
What, if any, steps have you taken to accomplish that?
I've been to Cumberland Heights one time, and I've been taking meetings. I've been going to AA meetings, and I have quit drinking somewhat, until I got in trouble.
Okay. While you've been incarcerated, have you applied at any places?
Yes, sir. I applied at Hope Center, which I've been accepted. I've applied at Cumberland Heights, which I've been accepted, and then at Aztec, and I've been accepted.
All right. And what is it that you're asking the court to do in regards to your bond today?
I would like, if possible, OR bond, so I can go home, get everything in order, and then go to rehab.
I'll pass the witness, Your Honor.
General Brooks?
Edward.
You said you could be successful in probation. Were you successful in probation last time?
I violated it.
Okay. And you were sentenced to serve the remaining of your sentence earlier this year, correct?
Yes, sir.
That was part of the reasons because you didn't show up, right?
I was drinking.
Okay. All right. You didn't report to probation.
No, sir, I stayed drunk the whole time. That's why I'm trying to get rehab, it was a problem.
But you said here today that you report to your court dates. What's the difference between reporting to your court dates and reporting to probation?
There's really not no difference, but I've never missed a court date.
And
And I have missed going to probation.
I'm not going to ask you about the underlying allegations. However, you understand you're charged, the highest level felony you're charged on this one is a C felony,
Yes,
aggravated
sir.
burglary, correct?
Yes, sir.
Normally, that carries a range of punishment of 3 to 6 years if you're a range one offender, right?
All right.
All right, but you have 2 prior felony thefts that would make you a range 2, correct?
I don't know how that works.
All right, you were previously on probation for a felony theft, $1,000 to $2,500 here in Dickson that was violated earlier this year, correct?
That's correct.
All right, and then you have a felony theft, $1,000 to $10,000 from Maury County back in 2010. Do you remember that?
Yes, sir.
Okay, so that would make you at least a range 2 on C felonies.
That was a wedding ring or a ring I gave a girlfriend, and we split up, and I took the ring back, and they charged me for theft with that, so.
So you say you own this property, you own it outright?
Yes, sir.
Okay. And Mr. Adams, I don't mind if you make bond with your property, but you understand that there's paperwork you need to submit.
I
with
couldn't
the- with the
afford it.
clerk.
Right, I couldn't afford the lawyer to submit that paperwork. They wanted like $700 to do that. And, I've recently lost my wife, she died, so I don't have nobody out there, that I can get money from. So that's why I came to the courts to try to get an OR bond.
And
So I could,
the current bond you're on, that was a bond that you and the prosecutor in sessions agreed upon to waive your preliminary hearing. Is that not correct?
no, they gave me a $12,000 bond when I came to jail.
But you waived your preliminary hearing and kept that bond the same, correct?
That's correct.
That's all I have, Judge.
Redirect, Mr. Howard. Thank you, sir. You may step down. Any other proof? State have any proof? You wish to be heard in argument? I'm required by law to look at the factors set forth in the Tennessee Code 4011-118 in determining the appropriate amount of a bond in a case. Those factors include the defendant's length of residence in the community, and he has been in the community in Dickson County for 60 some odd years. His employment status is basically as a carpenter. I don't know that there's any employer that was mentioned, but his family ties and relationships were not specifically spelled out. Reputation, character, and mental condition are not evidenced before the court. Prior criminal record of appearance of court proceedings, record of flight to avoid prosecution, and record of failure to appear at court proceedings. He has a prior criminal record that, as General Brooks has pointed out, if proven, he would likely have a range 2 rather than a range 1 sentence imposed if he is found guilty. The nature of the offense and apparent probability of conviction and a likely sentence. Mr. Adams is charged with aggravated burglary and theft. And although it was not a part of what was testified to at the hearing, the court reviewed the court file, and this is what the court finds in the affidavit of complaint. On 2/11/2026 at approximately 1600, I responded to a phone patch from Central Dispatch. During this phone patch, I was told by Zena B. Longacre that she had photos of her neighbor coming over to her house while she was not home, breaking into the home and leaving with 2 duffel bags of property. I asked Ms. Longacre to meet me at the sheriff's office so I could review the footage with her. Ms. Longacre was able to identify Charles Edward Adams as the primary suspect depicted in the photos and the one who opened the front door and made entry into the residence. The photos show Mr. Adams and another person not yet identified walking up the front door, moving the handle with some object, forcing entry into the residence. I did see scratch marks on door locks on the front door. Then Mr. Adams came walking out with a duffel bag in each hand. Mr. Adams had previously been trespassed from the property. Now, that evidence is what I expect would be at trial, in which case there is an extremely high probability of conviction of this case. And as a result of the fact that Mr. Adams has prior convictions, he may think he's not going to jail. That may be a completely different result than what he is expecting. And it may be that he goes into a drug court or gets into a rehab and gets himself straightened out. But there is no basis for me to reduce it, certainly not entitled to an OR bond. There is a strong likelihood of conviction of breaking into his neighbor's house, and I think that the protection of the public at least if nothing else, requires that his bond, in my opinion, the bond is extremely low for an offense that carries the possibility of multiple years of incarceration. So therefore, his motion for bond reduction is denied. Thank you. Mr. Adams, is he already set for a status day? All right. He'll remain under that same bond. All right, let's bring out the next inmate, please.
Yes, sir. Next up is going to be Jason Allen.
Mr. Baker. Where is Mr. Olin Baker? Hell yeah. I can't do the shock collar, maybe a long rope. We could tie a long rope around Mr. Baker's leg. Yeah, I'm sorry, I was.
Judge, Mr. Allen, I believe, has a superseding indictment he needs to be arraigned on, is my information.
All right, we do have a superseding indictment according to the docket. Need to arraign him on that.
And Judge, I represent him on the original indictment, so obviously I'm taking over this too. We'd enter a plea of not guilty, acknowledge receipt of the superseding indictment containing 8 counts. We'd waive the reading of the indictment.
All right. Plea of not guilty is entered, and is there a status day or a trial date?
Judge, this was its only status date set, and so we would need to set a new date in September.
September the 23rd for status. Thank you. Mr. Allen, if you'll step back, please. Mr. Baker, I'm inclined, I was asking if we had a long enough piece of rope to tie around one of your legs so that every time I turn around, I need you and you're outside. So.
Yeah, I think I told the general the minute I step out, they'll call another.
Luckily, we don't have, luckily for you, we don't have that long of a rope. So. That is the pot calling the kettle black right there. So, considering how many times you're outside of the courtroom.
Judge, up next is James Beck.
All right, bring out Mr. Beck. All right, Public Defender, Mr. Beck.
Yes, Your Honor. This is Mr. James Beck. Subject to the court's approval, he will resolve 2 of his cases today. He's got a pending violation of probation, which he'll resolve today with this plea, as well as new charges in 2025 CR 265. So there's 2 cases. One is the 2016 CR 588. That's a violation of probation. And then there's 2025 CR 265, and that's the new charges. Your Honor, he will enter an admission of the violation in the case ending 588. However, we'll note that his first probation term, first of 3 1129s in this probation, has already expired. He only has 2 of them remaining. Pursuant to that, he'll be revoked to serve those 2 original sentences in counts 3 and 4 of his the probation case. That will be 11 months and 29 days, followed by 11 months and 29 days, 2 ordinary misdemeanor sentences. And he has jail credit information entered onto this plea sheet. Then he will have in the new case, he will plead guilty to plead no contest, Your Honor, to count 2, a forgery, a Class D felony. The punishment will be 3 years, TDOC at range 1, but suspended to supervised probation. In count 3, he will plead no contest to Class D felony theft for 3 years, TDOC at range 1, suspended to supervised probation. And that will be concurrent with the 3 years in count 2. Conditions of this probation will be that He'll have monthly drug screens, zero tolerance for any failed drug screens. He'll have in-person reporting only. He'll have to pay restitution of $8,602.16 to Cache City in monthly zero tolerance payments, and he may not return to said Cache City. This sentence will be consecutive to the sentence that's in this violation of probation case, which was discussed before. Count 1 will be dismissed in settlement. So I'll have Mr. Beck sign these plea sheets. All right. It's May 13. It's your day for sending your name. Thank you, Mr. Beck. Mr. Beck has I think his violation of probation was set separately on June 29 of next month, Your Honor. So this will obviate having a hearing on that case.
All right, Mr. Beck, if you'll raise your right hand, let's place you under oath.
Yes.
Thank you. State your full name for the record.
James Keith Beck II.
As your lawyer has pointed out, you have two different types of cases, so I want to deal with them separately. I want to deal first with your probation violation. Do you understand that you have a right to plead not guilty to that charge and to have a hearing in this court where the state would be required to prove to the legal standard that you had violated your probation?
Yes, sir.
Do you also understand that you would have the right to have a lawyer and to have one appointed, as I've done with a public defender?
Yes, sir.
You understand if we had that hearing and I found you guilty of violating your probation, you could appeal whatever I did in your case to the Court of Criminal Appeals and have a lawyer appointed to help you with that appeal.
Yes, sir.
You understand that by pleading guilty, you're waiving your right to that hearing, to that appeal. All I'm going to do is to go forward with what your lawyer has worked out, and that's going to be that you're going to be revoked to serve the original sentence in counts 3 and 4, which is basically 2 consecutive 11-month and 29-day sentences, 2 years more or less.
Yes,
Do you
sir.
understand that?
Yes, sir.
Do you understand everything I've explained to you?
Yes, sir.
Do you want to plead guilty according to that understanding to the charge?
Yes, sir.
And upon your plea of guilty, I find you guilty, order that you be revoked to serve counts 3 and 4 of that sentence in that case. And that's 2016 CR 588. And you'll be revoked to serve them consecutively as was originally ordered. You get jail credits according to what your lawyer has included on the document. In docket number 2025-265, you have new charges of forgery and theft, and one of the counts is being dismissed. But have you seen or been shown a copy of those charges? Talked them over with Mr. Talbot, you and he discussed the range of punishment you're facing, as well as any possible defenses you might have.
Yes, sir.
Well, it's indicated you want to enter a plea of nolo contendere. That means that you're not going to admit you did anything wrong, but you're not going to contest the state's evidence. And as a result, the state will tell me what their proof would be at trial, and I'll use that evidence to find you guilty according to this agreement. And I'll uphold that agreement you've made with the state, but that's the factual basis for it. Do you understand that?
Yes, sir.
Do you understand, however, that you have a right to plead not guilty and have a speedy and public trial by jury?
Yes, sir.
You understand if you went to trial, you'd have the right to have a lawyer and have one appointed, as I've done with a public defender.
Yes, sir.
Do you understand that if you went to trial, you'd be presumed to be innocent until such time, if ever, the state proves your guilt beyond a reasonable doubt to the satisfaction of all 12 jurors, and it must be unanimous for their verdict to be unanimous for you to be convicted of anything?
Yes,
You
sir.
understand that? You understand that trial, you and Mr. Talbot could confront and cross-examine every witness the state called to testify, and you could bring in your own witnesses by using a subpoena.
Yes, sir.
You understand if you went to trial, you would be presumed to be innocent. You would not have to testify or prove anything, and no inference of guilt would arise because you did not testify at your own trial.
Yes, sir.
Do you understand if you went to trial and you were found guilty, you could appeal the conviction and the sentence imposed to the Court of Criminal Appeals and have a lawyer appointed to help you with that appeal?
Yes, sir.
You understand that by pleading no contest, you're waiving your right to a trial and to an appeal. All I'm going to do is approve what your lawyer's worked out on this.
Yes, sir.
You understand that's going to result in 2 convictions that are going to be both felonies, and they will be on your record in the future to make more severe the punishment you'll receive if you are ever again convicted of a crime.
Yes, sir.
Do you understand everything I've explained on this case?
Yes, sir.
Do you wish to plead no contest according to this agreement?
Yes, sir.
Is your decision to plead no contest today voluntary?
Yes, sir.
Anybody forcing you to do this against your will?
No, sir.
You understand I have to have these facts presented to me that will allow me to find you guilty.
Yes, sir.
And I want you to listen as the state tells me what their evidence would be at trial.
Your Honor, if the case had gone to trial in this case, the state would have put on evidence to show the offense date was October 8th of 2025 in this case. Mr. Beck had been a recipient of multiple checks through a trust fund. And back in August of 2024, he had received a check that had a clerical error on it, which made it invalid. He was contacted by the executor of the trust and told to discard the check and was issued a new one. He then cashed the new one, however, he maintained the old one, and a little over a year later, on October 8th of 2025, he altered the check from a 2024 year to 2025 and then cashed it at Cash City, where he received the amount of money and the check came back worthless.
I'm not asking that you agree with those facts, but do you understand that's what the state's evidence would be at trial?
Yes, sir.
You still wish to plead no contest?
Yes, sir.
Are you satisfied with your attorney's services?
Yes, sir.
Feel like Mr. Talbot's done a good job of representing you competently?
Yes, sir.
Mr. Talbot, do you know of any reason you should not enter this plea? Is there anything from the state, anything else from the state? Then James K. Beck in docket number 2025 CR 265, upon your plea of no contest to count 2, I find you guilty of forgery, sentence you to 3 years, Tennessee Department of Corrections, as a range 1 offender, suspended to supervised probation. Count 3, you're found guilty of theft, sentenced to 3 years, Department of Corrections, suspended to supervised probation, concurrent with count 2. These sentences are running consecutively to the 2 1129s that we just dealt with. You must, when you're on probation, you must undergo monthly drug screens with 0 tolerance for any failed drug screens. You must have only in-person reporting and pay restitution of $8,602.16 to Cash City in monthly payments. And there must be a 0 tolerance for any missed payments, and you may not return to Cash City. That's the judgment of the court.
Yes,
Thank
sir.
you. All right, who we have next?
Sir, next is going to be Randall Clark. Not up here, not up here.
I'm surprised it hadn't happened here, I mean, outside of the parking lot.
Your Honor, with Mr. Clark, I've been advised that he has some questions for me. May I please speak with Mr. Clark?
You
Oh,
may.
let's do that. Thank you.
All right, let's go ahead and bring, if we have another one.
Next up is going to be Daryl Dawson, Jr. Honor, this is Mr. Daryl Dawson. Subject to the court's approval, he will resolve his case today. Your Honor, he'll plead no contest to count 1, possession of Schedule 6, drugs with intent. That'll be a Class B felony. Note that on here. Your Honor, that will be 8 years TDOC at Range 1, suspended to supervised probation upon the time that Mr. Dawson has already served. He'll have a $2,500 fine and court costs. He'll have to forfeit any items that were seized to the Drug Task Force. Monthly drug screens with 0 tolerance, violation positive screens. He'll have in-person reporting only. However, he may apply for interstate transfer of probation supervision. And he is credited with the jail credits that are listed on this plea sheet. And I'll have Mr. Dawson sign where it says defendant.
Mr. Dawson, raise your right hand. Let's place you under oath.
Yes.
State your full name for the record.
Dawson,
Mr. Dawson, you're here today charged in a single count indictment with possession of controlled substance marijuana for purposes of resale over 70 pounds. It's been indicated that you want to enter a plea of nolo contendere or no contest. But have you seen or been shown a copy of those charges, talked them over with your lawyer, and discussed with him the possible range of punishment as well as any possible defenses you might have to the evidence?
Yes.
Well, step up a little bit to that microphone. We're recording everything that's being said. Do you understand that you have a right to plead no contest, which is what you're doing? And what that means is you're not going to admit you did anything, but you're not going to contest the state's evidence. And they will tell me what their evidence will be, and I'll use that evidence to find you guilty according to this agreement. Do you understand that?
Yes.
Do you understand, however, you have a right to plead not guilty and to have a speedy and public trial by jury?
Yes.
You understand that if you went to trial, you would have the right to have an attorney and to have one appointed, as I've done with a public defender?
Yes.
You understand if you went to trial, you'd be presumed to be innocent until such time, if ever, the state proves your guilt beyond a reasonable doubt to the satisfaction of all 12 jurors, and their verdict would have to be unanimous before you could be convicted of anything.
Yes.
You understand that if you went to trial, you and Mr. Talbot could confront and cross-examine every witness the state called to testify, and you could bring in your own witnesses by the use of a subpoena.
Yes.
Do you understand that you would be presumed to be innocent? You would not have to testify at your trial or prove anything, and no inference of guilt would arise because you did not testify at your own trial.
Yes.
You understand that if you went to trial and you were found guilty, you could appeal that conviction and the sentence imposed to the Court of Criminal Appeals and have a lawyer appointed to help you with that appeal.
Yes.
You understand that by entering this plea of guilty, of no contest, you're waiving your right to a trial and to an appeal. And all I'm going to do is approve what your lawyers worked out.
Okay.
Do you understand that's going to result in a conviction, and that conviction is going to be on your record in the future to apply to make more severe the punishment you will receive if you're ever again convicted of a crime?
Yes.
Do you understand everything I've explained to you?
Yes.
You want to plead no contest according to this agreement?
Yes.
Is your decision to plead no contest today voluntary?
Yes.
Anybody forcing you to do this against your will?
No.
You understand that I cannot accept your plea unless I'm satisfied you're guilty and there are facts to support it?
Yes.
And I want you to listen as the state tells me what their evidence would be if you went to trial.
Yes.
Your Honor, if the state had gone to trial in this case, the state would have put on evidence to show that on March the 14th, 2023, Mr. Dawson was traveling on the interstate in Dickson County and was stopped by the Drug Task Force due to traffic violations. Upon stopping him, there was an overwhelming smell of marijuana from the vehicle. Upon meeting with and speaking with Mr. Dawson outside of the vehicle, he also had an overwhelming smell of marijuana and was sweating profusely due to the smell and the characteristics of Mr. Dawson being nervous. And at answers to the questions he was given, they did a probable cause search and they found well over 70 pounds of marijuana in the vehicle.
I'm not asking that you agree with those facts, but do you understand that's the state's evidence that they would put on at trial?
Yes.
You still wish to plead no contest?
Yes.
Are you satisfied with your attorney's services? You feel like Mr. Talbot's done a good job of representing you competently?
Yes.
Mr. Talbot, do you know of any reason he should not enter this plea?
No, sir.
Then Darrell Dawson, in docket number 2023 CR 107, upon your plea of no contest to count 1 I find you guilty, sentence you to 8 years Tennessee Department of Corrections as a range 1 offender that will be suspended to supervised probation on time served and $2,500 fine and court costs. All items seized are forfeited to the Drug Task Force. You must undergo monthly drug screens with a zero tolerance provision for any positive drug screen, and you will have in-person reporting only. You may apply for an interstate transfer of probation supervision. All right, that's the judgment of the court. We just received a report that there was apparently a shooting at the front of the Justice Center in Clarksville. Have y'all heard anything about that? Supposedly just happened when Officer Sergeant Howell was taking one of the prisoners back to Montgomery County and said that there was apparently a shooting at the front door of the Justice Center there. So I just wanted to know if you know, I obviously am not in a position to look it up. Pardon? There was something there, though. We live in a bizarre society. So. Who do we have?
Up next is Timothy Dawson.
Timothy Dawson, Mr. Massengill.
I think we're just here on status, Your Honor. I represent Mr. Dawson. I've received discovery, met with him in Dickson County Jail and tendered a copy of discovery, so we just need to get a status date, Your Honor, so I have sufficient time to review.
Well, this is a probation violation, correct? And they had a new case?
Yes, Your Honor.
So status date of September the 23rd?
I'll be down here the 8th if I could get it on there, possibly, Your Honor, but I'll do the 23rd if the court prefers.
No, I mean, what are you saying?
Just a status date on both cases.
Well, I was giving you, the probation violation, you don't need a status date. You just need a hearing date. On the new case, I'll give you a status date. Are you wanting something further away than September?
I think maybe September, just, if I need more time, I'll request it then, but that way it just, stays on me,
We'll put it on September the 23rd of 2026. All of his cases will be on that day.
Thank you, Your Honor.
All right.
September 23rd, I'll be in touch.
Next up is Derek Dillard.
This is Ms. Crystal Wilkerson's case.
Yes, Judge, she had to leave and Mr. Talbot was going to stand in.
And we do have a plea sheet somewhere.
And I'll still have it.
Again, Your Honor, standing in for Ms. Crystal Wilkerson. This is Mr. Derek Lee Dillard, case number 24 CR 84. Mr. Dillard will be entering a no contest plea to count 1, that is possession with intent to sell meth. The punishment will be 8 years TDOC, concurrent with the sentence in case number 25 CR 130. Counts 2, 3, and 4 will be dismissed in settlement. This is a range 1 sentence running at 30%, and he does have time served from 9/17/25 to May the 13th, that's today, sorry, to today.
All right, Mr. Dillard, raise your right hand and let's place you under oath. Thank you. State your full name for the record.
Derek Lee Dillard.
Mr. Dillard, you're here today with on an indictment, multi-count indictment And it's been indicated that you're going to enter a plea to one of those counts, and the remaining counts will be dismissed. But have you seen or been shown a copy of those charges, talked them over with your lawyer, and have Ms. Wilkerson and you discuss the range of punishment as well as any possible defenses you might have? You feel like you fully understand what you're charged with?
Yes.
Well, it's indicated you want to enter a plea of nolo contendere. That means that you're not going to admit you did anything, but you're not going to contest the state's evidence, and they'll tell me what their evidence would be at trial, and I'll use that evidence to find you guilty according to this agreement. Do you understand that?
Yes, sir.
You understand that you can plead not guilty and have a speedy and public trial by jury?
Yes, sir.
You understand that if you went to trial, you would be presumed to be innocent, but you would also have the right to have an attorney and to have one appointed if you could not afford your own?
Sir.
You understand you would be presumed to be innocent until such time, if ever the state proves your guilt beyond a reasonable doubt to the satisfaction of all 12 jurors, and their verdict would have to be unanimous before you could be convicted of anything?
Yes, sir.
You understand that if you went to trial, you and Ms. Wilkerson could confront and cross-examine every witness the state called to testify, and you could bring in your own witnesses by using a subpoena. Do you understand that? Do you understand you'd be presumed to be innocent? You wouldn't have to testify or prove anything, and no inference of guilt would arise because you did not testify at your own trial. Need you to answer verbally, please.
Yes, sir.
All right. And we're recording everything, so I've got to have a verbal response. Do you understand that if you went to trial and you were found guilty, you could appeal the conviction and the sentence imposed through the Court of Criminal Appeals and have a lawyer appointed to help you with that appeal?
Yes, sir.
Do you understand that by entering this plea, you're waiving your right to a trial and to an appeal? All I'm going to do is approve what you and Ms. Wilkerson have worked out with the state.
Yes, sir.
Do you understand that's going to result in a conviction, and that conviction will be on your record in the future to make more severe the punishment you receive if you're ever again convicted of a crime?
Yes, sir.
Do you understand everything I've explained to you?
Yes, sir.
Do you want to plead no contest according to this agreement and waive your right to a trial and to an appeal?
Yes, sir.
Is your decision to plead no contest today voluntary?
Yes, sir.
Anybody forcing you to do this against your will?
No, sir.
Do you understand I cannot accept your plea unless I'm satisfied you're guilty and there are facts to support it?
Yes, sir.
Then listen as the state tells me what their evidence would be if you went to trial. General?
Judge, on May 16th, 2024, Detective Katrina Pulley was in an unmarked car at the Dollar General store, I think just stopping to pick something up. She observed a hand-to-hand transaction between the defendant and Anthony Justice, who was charged in a separate indictment. She backed her car out, initiated her blue lights, and held them until other officers could arrive. She asked for consent to search Mr. Dillard's car. Consent was denied. He later changed his mind. There was also a dog alert. He ultimately admitted that he did purchase marijuana from the other defendant, and he was found in possession of various narcotics, including the count he's pleading to, which was for 5 separate bags weighing 4.2 grams of methamphetamine.
All right, I'm not asking that you agree with those facts, but do you understand that's what the state's evidence would be if you went to trial?
Yes, sir.
You still wish to plead no contest?
Yes, sir.
Are you satisfied with Ms. Wilkerson's representation of you? You feel like your lawyer's done a good job? If you don't, I'm not going to accept this plea. So she's not here to answer that question. If you're not satisfied with your lawyer's services, then I will set this plea aside and we'll put you back on the trial docket. I don't care.
I was not satisfied with her service.
All right. I will not accept this plea in view of that fact. So, Mr. Dillard, you'll step back with them. We'll notify Ms. Wilkerson, and I will set it back I'm going to put it on May 27th. And at that point, we'll see where we are. Thank you, Mr. Howard. Next case.
Next is going to be LaQuinton Dotson.
The Dotson's on page 15. Okay.
Your Honor, in case number 2025 CR 213, Mr. Dotson is going to enter a plea of guilty on count 1 aggravated assault as a range 2 offender. He is going to receive a sentence of 8 years that will be suspended, and he'll be placed on state probation. He must report in person to probation, no contact with the victim or family members. He has to have a alcohol and drug assessment and follow recommendations, 0 tolerance on drug screens. He must wear a SCRAM device for the first year of probation, and it may be removed after 1 continuous year of no violations. So I need you to sign this right here. And Your Honor, in case number 2025 CR 237, he will be pleading guilty to count 1 violation of a no contact order. That'll be he'll receive a sentence of 11 months and 29 days, suspended to state probation. That will be consecutive to the case ending in 213.
All right, Mr. Dodson, raise your right hand. Let's place you under oath. Thank you. Step in front of that microphone and state your full legal name.
LaQuentin Lamonte Dotson.
Mr. Dodson, you're here today on 2 different indictments, and you've heard the agreement that's been announced, but have you been shown, and have you seen or been shown a copy of the charges against you? Talked them over with your lawyer and discussed with him the range of punishment you're facing, as well as any possible defenses you might have.
I have.
You feel like you fully understand what you're charged with?
I do.
You understand that you have a right to plead not guilty and to have a speedy and public trial by jury in this court.
I do.
You understand that if you went to trial, you would be presumed to be well, number one, you'd have the right to have a lawyer and to have one appointed if you could not afford your own.
Sir.
You understand if you went to trial, you'd be presumed to be innocent until such time, if ever the state proved your guilt beyond a reasonable doubt to the satisfaction of all 12 jurors, and their verdict would have to be unanimous before you could be convicted of anything.
I do.
You understand that if you went to trial, you and your lawyer could confront and cross-examine all witnesses the state might call to testify, and you could bring in your own witnesses by using a subpoena.
I do.
You understand you'd be presumed to be innocent. You would not have to testify or prove anything, and no inference of guilt would arise because you did not testify at your own trial.
I do.
You understand if you went to trial and you were found guilty, you could appeal that conviction and the sentence imposed to the Court of Criminal Appeals and have a lawyer appointed to help you with that appeal.
I do.
You understand that if you enter this plea, you are waiving your right to a trial and to an appeal. All I'm going to do is approve what you and your lawyer have worked out with the state.
Sir.
You understand that that's going to result in 2 felony convictions, or I'm sorry, 1 felony, 1 misdemeanor conviction. And those convictions will be on your record in the future to make more severe the punishment you receive if you're ever again convicted of a crime. You understand everything I've explained to you?
Yes, sir.
Do you want to waive your right to a trial and to an appeal by entering a plea of no contest? I'm sorry, plea of guilty.
Yes, sir.
And you understand if you plead guilty, the court of the state could ask you questions about this offense, and if you answer those questions under oath on the record and in the presence of your lawyer, your answers could later be used against you in a prosecution for perjury if we determine that you were lying under oath.
Yes, sir.
Is your decision to plead guilty today voluntary?
Yes, sir.
Anybody forcing you to do this against your will?
No, sir.
You understand I cannot accept your plea unless I'm satisfied you are in fact guilty and that there are facts to support it.
Yes, sir.
Then I will ask you this. Are you guilty of the charge of aggravated assault?
I am.
What happened?
Just pushed her around.
Okay. Is there any other additional facts that the state wants to put on?
Yes, Your Honor, this was on August 14th of 2025, and officers responded to 116 Reed Road in Dickson, Tennessee. And you heard the defendant say he pushed her around, but during this process, the victim, Miss Crystal, she was strangled. She went to the hospital with injuries to her face, marks on her neck, and bruises on her body, on her back, and she had complained a lot of neck pain. She did go by EMS to Horizon Medical Center, so it would be an aggravated assault based on the strangulation, Your Honor. He was under the influence at the time.
All right. Now, on the violation of no contact order, did he contact her after being placed under a bond condition?
He was placed under a no contact order as a condition of his bond, and on September 7th of 2025, he did call her from the Dickson County Jail. That was confirmed that he made a call in violation of that order on September 7th when booked in.
All right. Are you satisfied with your attorney's services, Mr. Dodson?
Yes, sir.
You believe Mr. Thompson done a good job of representing you in these cases?
Yes, sir.
Mr. Thompson, you know of any reason he should not enter these pleas?
No, Your Honor.
Anything further from the state?
Your Honor, I have a small statement from the victim that she asked me to read as part of her victim's impact statement.
All right.
And she said that this experience has left a lasting impact on my mind and body. It was a near-death event, and I live with heightened vigilance every day. I already was diagnosed with complex PTSD, and this has intensified that struggle and made it a lot harder for me. I am working diligently on healing physically. The impact was significant and nearly resulted in me being strangled to death. I was hit multiple times, and my glasses were broken. That would be it, Your Honor.
All right, then, in docket number 2025 CR 213, Mr. Dodson, I find you guilty of aggravated assault, a Class C felony, sentence you to 8 years in the Tennessee Department of Corrections. I will be suspended to probation on time served. You are required, as a condition of your probation, to report in person, to have no contact with the victim or any family members. There will be must undergo an alcohol and drug assessment and follow the treatment recommendations, and there will be zero tolerance for any drug screens that are positive. Also, you must wear a SCRAM device for the first year of your probation, and it may be removed after one continuous year with no violations. 2025 CR 237, you're found guilty of violation of a no contact order, sentenced to 11 months and 29 days in the county jail. That will be suspended to probation and will be consecutive to the prior case. So essentially, you're going to be on 9 years probation. He needs to see the probation department.
Thank you, Judge.
All right, thank you. Who do we have next?
Up next will be Randall Clark.
Can you skip over Clark? Go ahead, come up to the podium.
Judge, Mr. Ty Hicks on page 26, we'd like to move that to, what date? September 23rd.
Jeffrey Ty Hicks, September 23rd.
Okay, thanks, Judge.
Judge, up next is James Dubois Jr.
Mr. Spratt's case.
Status date on 9/8.
All right, so the motion to suppress will be on August the 14th, and then the status day or plea day will be September the 8th, correct? All right. Your lawyer couldn't be here today, but he is, co-counsel was asking for a date to set a motion to suppress, so we've given that date out. So August 14th on the motion to suppress. Thank you.
Judge, up next is going to be Christopher King.
Mr. Saul?
Judge, I'm here for Mr. King. He's obviously in custody, serving a sentence on another case, Your Honor. He has a co-defendant on this case, Miss Amanda Roberts. Her plea and allocution is most likely to have some effect on Mr. King. As a result, I was going to ask if the court would allow us to reset this for September 8th, just to see what the allocution is.
September 8th?
Yes, sir.
All right.
Thank you, Judge.
Up next, Judge, is Shemaine Johnson.
All right, I need to see Mr. Johnson's. I know he has a motion pro se. Mr. Johnson, you have been indicted by the grand jury of this county on the May term with possession of methamphetamine with intent, and which constitutes a Class A felony under the law. You have the right to an attorney. Do you wish to have a lawyer represent you?
Yes, sir.
Have you had a lawyer previously involved in your case?
Yes, sir.
Yeah.
Does the public defender know of any reason you could not represent? The co-defendant is Cleopatra Denise Lewis.
Your Honor, I represented Mr. Johnson in the Sessions case.
Then I'm going to appoint you to represent Mr. Johnson here. Now, you wish a formal reading of that indictment?
No, sir. On behalf of Mr. Johnson, waive formal reading and enter a plea of not
Plea of not guilty is entered. We'll set a status date for September the 8th. Now, he has a pro se motion to obtain records being held from the city of Dickson Dispatch. My suggestion would be that this would be something that you can assist him with. Now that you got a lawyer in the case, he can file a motion for discovery, issue a subpoena, whatever is necessary to obtain those records, and it'll be a lot more effective than any other method, okay?
Yes, sir.
So let's let Mr. Talbot, he's a very good lawyer, let him help you with it, and I think he'll take care of it for you, okay?
I appreciate it, Your Honor.
All right. Then we will set him for status September the 8th. Thank you.
And briefly, there was a Mr. Patrick Peters who was called earlier, and I guess did not answer. That is because he is in the Cheatham County Jail on it looks like violation of community corrections presently. Mr. Tummins with Pfizer bonding just brought me this.
Yeah, I did a conditional forfeiture. All right, so he's in Cheatham County. We'll set aside the conditional forfeiture, and he's in Cheatham County.
Yes, sir.
Well, if I set him for May 27th, that's more than 10 days. We should be able to get him here. May 27th.
Honor, may I approach?
You may. Thank you. All right, who we got next? Yes, sir.
On page 47, be Rebecca Rednauer.
Okay.
We're asking to move that to September 23rd. She has a pending Rutherford County case that Mr. Saul represents her on, and these cases are very related. We want to get the discovery, go over that together.
September 23rd.
Judge, up next is Charles Pruitt.
All right, public defender represents Mr. Pruitt. We need to set a status or a trial date. I don't know what,
On this, Mr. Pruitt's case, I think probably a status date would be appropriate. Yes, Your Honor, it looks like I'd like to get up to speed on this file, Your Honor, so I can advise Mr. Pruitt.
you want it for September the 23rd?
Thank you, Your Honor.
September 23rd for Mr. Pruitt. You may.
Bookkeeping purposes, I guess, Your Honor, Mr. Perry is my client, and he is back there, but, in the interest of efficiency, I've told bailiffs that we don't have to bring him out. I met with him yesterday, and I would just like for him, his space on the docket to reflect the 8/14 and 9/8 dates. That's Billy Perry on page 44.
All right, on page 44, docket number 2024 CR 137, there'll be a motion to suppress heard on August 14th, and the status date for it following that will be September 8th.
Thank you, Your Honor.
Thank you. We do not need Mr. Perry as a result.
Up next is Randall Robinson.
47.
Your Honor, this is Mr. Randall Seth Robinson. He's got 2 cases on the docket today. Subject to the court's approval, he intends to resolve these by agreement. Your Honor, in case number 2025 CR 171, Mr. Robinson will plead no contest to count 1, violation of the SOR. That's an E felony. He'll have 1 year to serve on that. He'll plead no contest to count 2 as well, violation of community supervision for life, and E felony. And that'll be 1 year to serve. That's consecutive to count 1. Then he will have, he's got his pretrial jail credits listed for this plea here. And then on case 2025 CR 172, he'll plead no contest to the charge of evading arrest, a Class A misdemeanor. He'll have 11 months and 29 days to serve. That is consecutive to 2025 CR 171 count 2. So basically would work as 1 year, then 11 months, 29 days. Count 1 of 172 is dismissed in settlement. All right, so if you can sign that, defendant, and, oh, it's already been dated.
All right. Mr. Robinson, raise your right hand. Let's place you under oath.
Yes, ma'am.
State your full name for the record.
Randall Seth Robinson.
Mr. Robinson, you have heard what your lawyers announced as the agreement, but have you seen or been shown a copy of the charges against you and indicated that you, or rather have you and Mr. Talbot had an opportunity to go over those evidence in your case and what your charges are so that you fully understand the nature of the charges and any possible defenses you might have?
Yes, Your Honor.
Well, it's indicated you want to enter a plea of no contest. All that means is you're not going to admit you did anything, but you're not going to contest the state's evidence. And when they tell me what their evidence is, I will use that evidence to find you guilty according to this agreement. Do you understand that?
Yes, Your Honor.
You understand, however, that you can plead not guilty and have a speedy and public trial by jury.
Yes, Your Honor.
You understand that if you went to trial, you'd have the right to have a lawyer and have one appointed if you cannot afford your own.
Yes, Your Honor.
You understand that if you went to trial, you would be presumed to be innocent until such time if ever the state proved your guilt beyond a reasonable doubt to the satisfaction of all 12 jurors. Their verdict would have to be unanimous before you could be convicted of anything.
Yes, Your Honor.
You understand that if you went to trial, you and Mr. Talbot could confront and cross-examine every witness the state called to testify against you, and you could bring in your own witnesses by using a subpoena.
Yes, Your Honor.
Do you understand at trial you would be presumed to be innocent? You wouldn't have to testify or prove anything, and no inference of guilt would arise because you did not testify at your own trial.
Yes, Your Honor.
Do you understand that if you went to trial and you were found guilty, you could appeal the conviction and the sentence imposed to the Court of Criminal Appeals and have a lawyer appointed to help you with that appeal?
Yes, Your Honor.
Do you understand that by pleading guilty, you're pleading no contest? You're waiving your right to a trial and to an appeal. All I'm going to do is approve what your lawyer has worked out.
Yes, Your Honor.
But that's going to result in convictions that are going to be on your record in the future to make more severe the punishment you'll receive if you're ever again convicted of a crime.
Yes, Your Honor.
Do you understand everything I've explained to you?
Yes, sir.
Do you want to waive your right to a trial on these charges by entering a plea of no contest?
I do, Your Honor.
Is your decision to plead no contest today voluntary?
Yes.
Anybody forcing you to do this against your will?
No, sir.
Do you understand that I can't accept your plea unless I'm satisfied you're guilty of these charges and there are facts to support it?
Yes, Your Honor.
Then I want you to listen as the state tells me what their evidence would be if you went to trial.
Judge, if this case went to trial, the proof would be that Mr. Robinson entered a no contest plea to aggravated sexual battery back in 2010. That is an offense that puts him on the sex offender registry, as well as subjecting him to community supervision for life. On April the 8th, he was released from custody on a different offense and did not report and register with the sex offender registry within 48 hours. That also triggered a subsequent community supervision violation because of the sex offender registry violation. In June of 2025, he was observed by law enforcement who knew that he had an active warrant. They called out to him, requested for him to stop, and he ran and hid. That is the evading.
All right, Mr. Robinson, do you understand that's what the state's evidence would be at trial?
Yes, Your Honor.
You still wish to plead no contest?
Yes, Your Honor.
Are you satisfied with your attorney's services?
Yes, Your
I
Honor.
feel like Mr. Talbot's done a good job of representing you competently.
Yes, Your Honor.
Mr. Talbot, do you know of any reason you should not enter this plea? Then anything further from the state?
No, Judge.
The Randall Seth Robinson in docket number 2025 CR 171 upon your plea of no contest to count 1, find you guilty of violation of the sex offender registry requirements and sentence you to 1 year Tennessee Department of Corrections to serve. Count 2, you're found guilty, sentence to 1 year as well to serve. That will serve consecutively to the case that you are to the prior count. So that's a second year to serve. And in docket number 2025 CR 172, upon your plea of no contest to evading arrest, I find you guilty, sentence you to 11 months and 29 days in the county jail to serve consecutively to the prior indictment for an effective 3 years of service. That's the judgment of the court. Thank you.
Judge, up next is Gary Shadowins Jr.
John, I'm just gonna have him sign the forms. It's easier just to do it right here.
That's fine.
But I've gone over them with him and explained all of his rights to him.
All right, I've been handed two different documents in docket number 2024 CR 65 I've been indicated that he's going to plead guilty to misdemeanor assault in counts 1 and 2. Remaining counts would be dismissed. He would serve 11 months and 29 days in the county jail consecutively, and that would be for 2 11/29s consecutive. In docket number 2024 CR 180, he would be pleading guilty to one count of aggravated assault, receive a sentence of 4 years suspended. That would be consecutive to count 2. Count 2 is 4 years suspended, and that would also be for aggravated assault. And it's indicated if he violates it, he will serve at 100% plus 15% credit, both consecutive to the prior case that he has to serve. So if I understand it correctly, he is going to be serving 2 11 months and 29-day sentences in the first indictment. And then following his service of those, he'll be on 4 years suspended probation.
That's correct, Your Honor. And with his jail credits, he's probably real close to getting out.
All right. Mr. Shadowins, raise your right hand. Let's place you under oath.
I do.
Thank you. State your full name for the record.
Gary Lee Shadowins Jr.
Mr. Shadowins, you've heard me go over what your agreement is, and have you and Mr. Lockhart had an opportunity to go over it and talk about what you're facing as far as the charges against you and the range of punishment and possible defenses you might have?
Yes, sir.
Well, it's indicated you want to enter a plea of guilty. Do you understand you have a right to plead not guilty and have a speedy and public trial by jury?
Sir.
Do you understand that if you went to trial, you'd have the right to have a lawyer and have one appointed if you could not afford your own? Do you understand that if you went to trial, you'd be presumed to be innocent until such time if ever the state proved your guilt beyond a reasonable doubt to the satisfaction of all 12 jurors, and their verdict would have to be unanimous before you could be convicted of anything?
Yes, sir.
Do you understand that if you went to trial, you and Mr. Lockhart could confront and cross-examine every witness the state called to testify, and you could bring in your own witnesses by the use of a subpoena?
Yes, sir.
Do you understand that if you went to trial, you would be presumed to be innocent, you would not have to testify or prove anything, and no inference of guilt would arise because you did not testify at your own trial?
Yes, sir.
You understand that if you went to trial and you were found guilty, you could appeal that conviction and the sentence imposed to the Court of Criminal Appeals and have a lawyer appointed to help you with that appeal?
Yes, sir.
You understand that by entering this plea of guilty, that you are waiving your right to a trial and to an appeal. All I'm going to do is approve what your lawyer is going to work out.
Yes, sir.
But you understand that's going to result in 4 different convictions, 2 misdemeanors and 2 felonies. And those are going to be on your record in the future to make more severe the punishment you'll receive if you're ever again convicted of a crime.
Sir.
You understand everything I've explained to you?
Yes, sir.
Do you want to plead guilty according to this agreement? Do you understand if you plead guilty, the court of the state could ask you questions about these offenses, and if you answer the questions under oath on the record and in the presence of your lawyer, your answers could later be used against you in a prosecution for perjury if we determine you were lying under oath?
Yes, sir.
Is your decision to plead guilty today voluntary? Anybody forcing you to do this against your will?
No, sir.
Do you understand I cannot accept your plea unless I'm satisfied you are guilty and there are facts to support it?
Yes, sir.
Then I will ask you in docket number 2024 CR 65, are you guilty of the 2 counts of assault?
Yes, sir.
Can you tell me what happened?
Pointed a BB gun at 2 police officers.
Okay. Pointed a BB gun at 2 police officers? All right. And in docket number 24 CR 180, there are 2 counts of aggravated assault. Are you guilty of that as well?
Sir.
What happened in that case?
Me and my cousin was hitting each other.
You and your cousin what?
Was hitting each other.
Okay. Did you hit him with something?
Yeah, I hit over a piece of pipe.
You hit, so it wasn't you were just hitting them each other, but you used a pipe to hit your cousin?
Yeah.
Okay. General Sylvia, do you have anything else you want to add to that?
The only thing I would add is that for the aggravated assaults with the pipe, Miss Michelle Alexander did have broken fingers in her hand. as a result of being hit with the pipe, as well as there was actually 2 victims, why there's 2 different counts. Miss Alexander's daughter, Brittany Alexander, was also hit with the pipe during this altercation with the cousins.
All right. Are you satisfied with your attorney's services?
Yes, sir.
Feel like Mr. Locker's done a good job of representing you competently?
Yes, sir.
Mr. Locker, do you know of any reason you should not enter this plea?
I do not, Your Honor.
Then Gary Lee Shadow is the docket number 2024 CR 65. Upon your plea of guilty to count 1, I find you guilty of assault, sentence you to 11 months and 29 days in the county jail that will be served. And count 2, you're found guilty of assault, 11 months and 29 days in the county jail to serve. Those 2 will be consecutive to one another. All remaining counts of that indictment are dismissed, and you're given pre-sentence jail credits as set forth on this document. In 2024 CR 180, upon your plea of guilty to count 1, I find you guilty of aggravated assault, sentence you to 4 years, Tennessee Department of Corrections, suspended to probation. It will be consecutive to the case that we just dealt with. And count 2, you found guilty, sentenced to 4 years. That will also be suspended to probation. And both of these will be consecutive to the prior count of 24 CR 65. And you're ordered to understand, rather you need to understand, if you violate your probation on those 2 aggravated assaults, you'll serve it at 100% less a 15% credit. And both of those are consecutive to the prior case, but concurrent to one another. So in other words, here's 4 years probation after, is it 8?
8 years, Your Honor.
8 years. So those 2 are consecutive to counts. All right, I see
He'll
that.
have 8 years probation once he finishes the
All right,
2
8
misdemeanors.
years probation. All right, thank you.
And since he has so much jail credit, I'm assuming he'll get out pretty quick. Will he need to talk to probation now?
Probably does need to go ahead and talk to him. Okay, thank you.
Your Honor, while I'm here, on page 31 of the docket, John Robert Hunt, the state has agreed we can reset his bond motion to the 20th. He had a grandmother pass, and his parents that were family that was going to be a witness in his bond motion couldn't be here.
All right,
I've already advised him, so I don't need to bring him out.
May 20th, all right.
Thank you, Your Honor.
We do not need Mr. Hunt, John Robert Hunt, but who else do we have back there? All right, page 57.
Your Honor, this is Mr. Jeffrey Wells. Today, he will settle his case, subject to the court's approval, by pleading no contest to count 1, felony theft. Punishment on that will be 6 years TDOC at range 1, suspended to probation after serving 6 months in the Dickson County Jail. He'll have credit for the time he served. Monthly drug screens with 0 tolerance for positive screens and in-person reporting only will be conditions of his probation. He'll have to pay court costs. There will be no contact with Timothy Waller or Clyde Harper. He may not return to 1140 Clay Lick Road in White Bluff, Tennessee. And this is to be concurrent with any other sentence that may be in effect. I don't know that he has one. It's just that he may have had one that was close to this, and so we wanted to put that in there as an abundance of caution, out of an abundance of caution, Your Honor. And then this is a range 1 sentence. He's got pretrial jail credits, Your Honor, going from November 8, 2025 to May 13, 2026, making 186 days. Now the court's going to ask some questions.
All right, Mr. Wells, raise your right hand. Let's place you under oath.
ma'am.
State your full name for the record.
Jeffrey Scott Wells, Jr.
Mr. Wells, you've heard your lawyer go over what the agreement is, but have you seen or been shown a copy of the charges against you and discussed it with Mr. Talbot so that you fully understand the nature of the charge and what your range of punishment might be and what the evidence is against you?
Yes, sir.
Well, it's indicated that you want to enter a plea of nolo contendere or no contest. All that means is you're not going to admit you did anything wrong, but you're not going to deny or contest the state's evidence. And when they give me their evidence, I will find you guilty according to this agreement using their evidence. Do you understand that?
Yes, sir.
Do you understand, however, that you can plead not guilty and have a speedy and public trial by jury? Do you understand if you went to trial, you'd have the right to have a lawyer and have one appointed if you could not afford your own?
Yes, sir.
You understand if we went to trial that you would be presumed to be innocent until such time if ever the state proved your guilt beyond a reasonable doubt to the satisfaction of all 12 jurors, and their verdict will have to be unanimous before you could be convicted of anything. You understand that if you went to trial, you and your lawyer could confront and cross-examine every witness the state called to testify against you, and you could bring in your own favorable witnesses by using a subpoena. You understand that if you went to trial, you'd be presumed to be innocent. You would not have to testify or prove anything, and no inference of guilt would arise because you did not testify at your own trial.
Yes, sir.
You understand that if you went to trial and you were found guilty, you could appeal the conviction and the sentence imposed to the Court of Criminal Appeals and have a lawyer appointed to help you with that appeal.
Yes, sir.
You understand that by entering this plea, you're waiving your right to a trial and to an appeal. All I'm going to do is approve what your lawyers worked out.
Yes, sir.
But you understand that's going to result in a felony conviction that's going to be on your record in the future to make more severe the punishment you'll receive if you're ever again convicted of a crime.
Yes, sir.
Do you understand everything I've explained to you?
Yes, sir.
You want to plead no contest according to this agreement and waive your right to a trial. Is your decision to plead no contest today voluntary?
Yes, sir.
Anybody forcing you to do this against your will?
No, sir.
You understand that I cannot accept your plea unless I'm satisfied there's a factual basis for it and that you are in fact guilty. And I want you to listen as the state tells me what their evidence would be if this case went to trial. General?
Your Honor, if this case had gone to trial, the state would have put on the evidence to show that on September 16, 2025, that two gentlemen were in the garage of one of the residents' home, having a beer after work, and Mr. Wells came by the garage and asked if he could have a beer. They gave him a beer and he left. However, when he left, Mr. Wells took the opportunity to take the truck that belonged to one of the gentlemen and left in the truck that had it was a work truck that was being used by Timothy Waller, was being used by Clyde Harper, but belonged to Timothy Waller. Took the truck that was full of tools. Later that same evening, the truck was recovered over at a grocery store in White Bluff, and multiple witnesses said that they observed Mr. Wells in the vehicle and then dropping the vehicle off and getting into another vehicle with Nicholas Creech. That would be the evidence, Your Honor.
Mr. Wells, do you understand that's the state's evidence? You still wish to plead no contest?
Yes, sir.
Are you satisfied with your attorney's services?
Yes, sir.
I believe that Mr. Talbot's done a good job of representing you competently.
Sir.
Mr. Talbot, you know of any reason you should not enter this plea? Then Jeffrey Scott Wells in docket number 2025 CR 245, upon your plea of no contest to count one, I find you guilty, sentence you to 6 years Tennessee Department of Corrections as a range 1 offender that will be suspended to probation after serving 6 months in the county jail with credit for time served. You must undergo monthly drug screens with zero tolerance for positive screens and in-person reporting only in order to pay the court costs and have no contact with Timothy Waller, Clyde Harper. May not return to 1140 Clay Lake Road, White Bluff, and you must, this will be served concurrently with any other sentence you may have. So he needs to see the probation. You have anybody else back there? Okay. I do not understand. Thank you. Sorry, I didn't understand.
This is Mr. Wren, and I don't know if this is the case I'm on or the new charge. I'm not sure. Obviously, you wasn't here last month. The judge heard this, Mr. Wren, they had filed a motion to revoke his bail. And obviously, they set this 520 and then hear the bond issue.
Right. Well, we'll set it for next month in June then, so. You want to do it in June? All right, May 27th. So this is a bond that was revoked by Judge Turnbow, and you're asking me to reinstate it? I'm just asking.
Pretty much, yeah.
Right. Was that the last inmate right now? I know we may have some second calls. Anybody back there we haven't dealt with?
I'm about to start with the female.
Well, let's take a recess. I got to stand up for a while, so. We'll be in recess for 15 minutes.
All rise. Court is in recess for 15 minutes.
All right, you have female inmates.
We still have one male, Randall Clark. He's ready to go.
Are you ready on Mr. Clark?
Your Honor, this is Mr. Randall Clark. Today, he will resolve his case subject to the court's approval by pleading no contest to count 1 DUI first. This is a Class A misdemeanor. Mr. Clark's punishment will be 11 months and 29 days suspended to probation after serving 48 hours in jail. He's already spent significant time in jail, and he'll have credit for that time served, so it should eliminate the need to serve 48 hours. He will have a DUI school or a victim impact panel as a condition of his probation. He'll have to have a license revocation for 1 year. There will be a $350 fine and court costs. Mr. Clark, if you can date here, sign there. That's your name here. It's May 13th, 2026. And then there's also this DUI punishment form, which I explain the enhancements if you get future DUIs. If you'll sign there, please. Can you give a request from the court? Second. Sign there. Mr. Clark? All right. Thank you.
All right, Mr. Clark, raise your right hand. Let's place you under oath. You solemnly swear or affirm the testimony you're about to give in this case to be the truth, the whole truth, and nothing but the truth, so help you God.
Pretty much always have, yeah.
All right, that's fine. State your full name for the record.
Randall L. Clark.
Mr. Clark, you are here today on a charge of driving under the influence of an intoxicant. Want to make sure you understand your rights. Do you understand that you have what you're charged with, and have you and Mr. Talbot had a chance to talk about the range of punishment and the evidence the state has against you?
I don't know if I've seen that much evidence, but.
Well, do you feel like you understand what you're charged with?
Yeah,
All right. Do you also understand that you have the right to plead not guilty and to have a speedy and public trial by jury on this charge?
yeah,
Do you understand that if you went to trial, you'd have the right to have a lawyer and have one appointed, as I've done with a public defender?
yeah,
You understand that if you went to trial, you'd be presumed to be innocent until such time, if ever the state proved your guilt beyond a reasonable doubt to the satisfaction of all 12 jurors, and their verdict would have to be unanimous before you could be convicted of anything?
yeah,
You understand that if you went to trial, you and Mr. Talbot could confront and cross-examine all witnesses the state called to testify, and you could bring in your own witnesses by using a subpoena?
yeah,
You understand that if you would be presumed to be innocent at trial, you would not have to testify or prove anything, and no inference of guilt would arise because you did not testify at your own trial?
yeah,
You understand? In other words, the state has to prove you guilty. You don't have to prove you're not guilty. You understand that?
yeah,
Do you understand that if you went to trial and you were found guilty, you could appeal that conviction and the sentence imposed to the Court of Criminal Appeals and have a lawyer appointed to help you with that appeal?
yeah,
You understand that by entering this plea of no contest, you're waiving your right to a trial and to an appeal. All I'm going to do is approve what your lawyers worked out, which is that you're going to be found guilty of the DUI first, but give you credit for your time served.
You mean the months, or are you talking the days that I served? Or are you talking the months that I served?
Well, I'm saying all the time that you've served on this charge that you'd be entitled to it.
Yeah, I read about the charge was supposed to be originally for the days too, but I've served way more than that, but yeah.
All right. Do you understand everything I've explained to you thus far?
Yeah,
Okay. Do you understand that by pleading no contest, you're waiving your right to a trial and to an appeal?
at this time, yeah.
All right. What do you mean at this time?
Yeah,
Okay. And do you understand this is going to result in a conviction for driving under the influence of an intoxicant that's going to be on your record in the future to make more severe the punishment you receive if you're ever again convicted of a crime?
yeah,
And you have been shown a copy of the notice of DUI punishment and enhancement that you've signed off on that tells you all of the different convictions all of the different punishments that will follow for each additional conviction. Do you understand that?
yeah, I asked for a copy of it, copy of all that,
All right. You understand everything I've explained to you?
pretty much, yeah.
All right. You understand, is your decision to plead no contest today voluntary?
At this time, yeah.
And when you say at this time, that causes me some concern.
Say, yeah,
Okay. You understand anybody forcing you to do this against your will?
not on this one, no.
Not on this one. All right. Let me see this file. Mr. Clark, this case goes back to 2022, some 4 years.
Yeah, that's my reckoning exactly, because I lost 2 automobiles that had a cycle vandalized and lost a structure I owned in the home place and everything. Been involved with this case, so yeah, I fully understand.
All right. And all I'm trying to find out is if there's some reason that you would object to or that you don't agree with this disposition. What this is going to mean is you're going to be found guilty and you're going to be released based on the time you served on this case.
Yeah,
If you don't want to do that, then we'll put you back in jail and set you for trial.
well, yeah, if the only reason I'm doing that is because I couldn't get anything else worked out at the moment, but yeah.
I'm sorry, repeat what you just said.
I said I couldn't get anything else worked out at the moment, so yeah, I understand that.
Okay. So do you want to then dispose of your case according to this agreement?
Yeah,
Okay. All right. Do you understand that I have to have facts presented to me that would justify me finding you guilty? Listen to the state as they tell me what their evidence would be if this case went to trial.
Judge, if this case went to trial, the proof would be that on February the 5th of 2022, dispatch in Dickson County received several hang-up calls to 911. A male called 3 different times and refused to give any information about why he was calling. The dispatcher would testify that he sounded intoxicated. Officer Sierra Repogal with Dickson Police Department went out to Golden Eagle Pond, which was the address of that call, and found the defendant sitting parked in a car in the middle of the parking lot. He was on his phone, and dispatch had advised that the person who had called would still be on the phone with them. So Officer Repogal approached, and she was able to see a half-full 25-ounce can of natural light sitting in between his legs. She attempted to speak to him, and he just stared at her and would not speak. When he finally did speak, he was slurring, and she couldn't understand him. She asked him to step out and observed him take the car key out of the ignition. When he got out of his car, he almost fell on the pavement because he was stumbling. He advised that he had had 1 beer and began to make several statements that did not make sense. He did not perform any field sobriety tests because he said his legs wouldn't allow him to. When officers tried to check his pupils, he told them to prove yourself, you're not the real Metro Police Department. And then he was arrested for driving under the influence, first offense.
All right, Mr. Clark, those are the facts that the state relies upon. Are you?
May I ask you a question?
Sure.
I was gonna listen to Judge, but I just want to know, if I ask the officer to present his ID to prove that he's who he says he is because of some incidences, does he have to do that?
Not necessarily. It depends on what the circumstances are. It may be completely justified, but it may not be something necessary depending on what the circumstances are. If an officer is dressed in a uniform and is wearing all of the identification matters.
Can I let you know why I'm asking this question?
Not really, no.
Because I was at well, I understand you're saying no, but I'm giving you the reason why I was asking.
That's fine.
I was at a cycle shop and I called the police department, asking this officer was at the cycle shop was with their department, and they told me no. So that's the reason I asked that question.
All right. Mr. Clark, I know that this case has been pending at least in part because we've had psychological evaluations performed on you to try to make sure that you were competent to stand trial and that it didn't support an insanity defense. And that's part of the reason this case has been pending for so long. But based on the evidence before me, I find that you are guilty of driving under the influence and sentence you to 11 months and 29 days, suspended to probation after 48 hours jail credit for time served. You are required to attend the DUI school or victim impact panel, and his license to drive is revoked for 1 year. He's ordered to pay a $350 fine at cost. You are given credit for all of the time that's set forth on the document here, all of the different times that you've been incarcerated. You'll be given credit for all of that. All right, thank you. All right, then we're ready for the females. All right, who is it?
Would the court allow us to address Mr. Stewart's case?
All right.
Thank you, Your Honor. Subject to the court's approval, Mr. Stewart will plead no contest to count one theft in this indictment. That's a Class C felony. That's going to be a punishment of 3 years TDOC at range 1, suspended to community corrections. He'll have to pay restitution joint and several with Sean Stewart in the amount of $14,850 to Stephen Adams, and he'll have to pay court costs. There will be in-person reporting and zero tolerance for positive drug screens, and there will be drug screens at least once per month. And Mr. Stewart has signed this plea agreement.
Mr. Stewart, raise your right hand. Let's place you under oath. State your full name for the record, please. Mr. Stewart, you're here today on an indictment charging you with theft. Have you seen or been shown a copy of those charges? Talked them over with Mr. Talbot. You and he discussed the range of punishment you're facing as well as any possible defenses you might have. Well, it's indicated that you want to enter a plea of no contest. That simply means you're not going to admit you did anything wrong, but you're not going to contest the state's evidence when they tell me what the facts would be at trial. And that evidence will be used by me to find you guilty according to this agreement. You understand that? All right, step up to that microphone and speak a little louder. We're recording this. Do you understand, however, that you can plead not guilty and have a speedy and public trial by jury in this court? You understand if you went to trial, you'd have the right to have a lawyer and have one appointed if you cannot afford your own. Of course, we've done that with a public defender. You understand that if you went to trial, you'd be presumed to be innocent until such time, if ever the state proved your guilt beyond a reasonable doubt to the satisfaction of all 12 jurors, and their verdict would have to be unanimous before you could be convicted of anything. You understand that if you went to trial, you and Mr. Talbot could confront and cross-examine all witnesses the state called, and you could bring in your own witnesses by the use of a subpoena. But you got to speak up because this is being recorded. Do you understand that if you went to trial, you'd be presumed to be innocent, you would not have to testify or prove anything, and there'd be no inference of guilt that would arise because you did not testify at your own trial? Do you understand that if you went to trial and were found guilty, you could appeal that conviction and the sentence imposed to the Court of Criminal Appeals, and have a lawyer appointed to help you with that appeal? Do you understand that if you went to, that if you enter this plea of no contest, you're waiving your right to a trial and to an appeal? All I'm going to do is approve what your lawyers worked out, but do you understand that? Do you understand this is going to result in a conviction that's going to be on your record in the future to make more severe the punishment you receive if you are ever again convicted of a crime? Do you understand everything I've explained to you? Pardon? Do you want to plead no contest and waive your right to a trial and to an appeal? Is your decision to plead no contest today voluntary? Anybody forcing you to do this against your will? You understand I have to have facts that are supporting finding of guilt in this case, so I want you to listen to the state as they tell me what their evidence would be if this case went to trial.
Your Honor, if this case had gone to trial, the state would have put on proof to show that on December 17th of 2024, the owner of a business, the Cumberland Furnace Commerce Center, had reached out to the detectives in regards to a theft from his facility. During the investigation, the officers were able to determine that some of the items that had been stolen that were fairly unique items had been posted on Facebook Marketplace. Throughout the investigation, they determined that Sean Stewart had been posting the items for sale on a Facebook Marketplace. Sean Stewart is the son of Jamie Stewart, and Jamie Stewart had worked for this company, but had been let go prior to this incident. Jamie Stewart still had a key to the building, and ultimately upon talking to Sean Stewart, they were able to determine that he admitted that he was selling these items for his father and that he'd gone with his father and taken those items. That'd be the state's proof.
All right. Are you satisfied with your attorney's services? Feel like Mr. Talbot's done a good job representing you? Mr. Talbot, do you know of any reason you should not enter this plea? And James Allen Stewart, in docket number 2025 CR 103, upon your plea of no contest to count one, I find you guilty, sentence you to 3 years Tennessee Department of Corrections as a range 1 offender. You'll be suspended to community corrections. You're ordered to pay restitution joint and several with Sean Stewart in the amount of $14,850 to Stephen Adams and to pay the court costs. You will be required to make in-person reporting and have zero tolerance for any positive drug screens. Drug screens will be at least one time per month. He needs to see the probation department. All right, we're ready for the inmates.
Judge, can we take up a plea if somebody's in the audience?
All right.
And that would be Miss Lacey Angelica Jordan Lackey. It's 2024 CR 236. That should be found on page 35 of the docket, Judge. And in the file should be a plea sheet and a diversion sheet from TBI. And in this case, Miss Lackey would enter a plea to count one, an amended count of attempted exposure of a child or child abuse under 8. And to count 2, amended to attempt, same charge, under 4035-313. Both sentences are 3 years suspended to probation. They'll be concurrent, pay the court cost, and contact with the victim, which are the children, as permitted by the juvenile court orders. It was, I guess, a companion DCS dependent neglect case, so there's some orders out of there that have to be complied with. Ms. Lackey has jail credits from 4925 to 42425. All got it, Judge.
All right. Ms. Lackey, if you'll raise your right hand, let's place you under oath.
Yes, ma'am.
State your full name for the record.
Lacey Angelica Jordan Lackey.
Ms. Lackey, you are here today charged with a multi-count indictment, and it's been indicated you want to enter a plea of no contest to 2 of those counts. The no contest simply means you're not going to admit you did anything, but you're not going to contest the state's evidence, and the state will tell me what their facts would be at trial, and I'll use those facts to make a finding of guilt in this case. Do you understand that?
Yes, sir.
You understand that you're entering a plea under 4035-313 because you have no prior criminal record. And I'll explain more fully about that, but that simply means that you might have a chance to have your record expunged if you're successful on your probation. Expungement means it would be wiped clean as though it never happened. You understand that? You understand what you're charged with, and you and Mr. Baker talked about the range of punishments you're facing as well as any possible defenses you might have. Well, it's indicated that you want to enter this plea of no contest. Do you understand you have a right to plead not guilty and have a speedy and public trial by jury?
Yes, sir.
You understand that if you went to trial, you would have the right to have a lawyer and to have one appointed if you cannot afford your own. You understand that if you went to trial, you would be presumed to be innocent until such time, if ever the state proved your guilt beyond a reasonable doubt to the satisfaction of all 12 jurors, and their verdict would have to be unanimous before you could be convicted of anything. You understand that if you went to trial, you and Mr. Baker could confront and cross-examine every witness the state called to testify, plus you could bring in your own witnesses by the use of a subpoena.
Yes, sir.
You understand that if you went to trial, you would not have to testify or prove anything, and no inference of guilt would arise because you did not testify at your own trial.
Yes, sir.
You understand if you went to trial and you were found guilty, you could appeal that conviction and the sentence imposed to the Court of Criminal Appeals and have a lawyer appointed to help you with that appeal. Do you understand that by entering this plea of no contest, you're waiving your right to a trial and to an appeal? All I'm going to do is approve what your lawyers worked out.
Sir.
And as I explained, you are going to be placed on probation for a period of 3 years. Essentially, you're handing me a guilty plea or a plea of no contest, and I'm going to put it in your file. And for 3 years, you're going to be on probation. If you successfully complete your probation, do everything you're supposed to do, at the end of that 3 years, your case can be dismissed and you can have your record expunged. Do you understand that?
Yes, sir.
But by the same token, if you violate the terms of your probation, you get arrested on some new charge, then not only would you come back in and you be sentenced to go to jail for those 3 years, but you could actually be given more time than that within the range of punishment applicable for the offense, and it would become a permanent conviction on your record and would be there in the future to make more severe the punishment you'll receive if you're ever again convicted of a crime. You understand all that?
Yes, sir.
You understand everything I've explained to you thus far?
Yes, sir.
Do you want to plead no contest according to this agreement and waive your right to a trial?
Yes.
Is your decision to plead no contest today voluntary?
Yes.
Anybody forcing you to do this against your will?
No, sir.
You understand I can't accept your plea unless I'm satisfied there are facts to support it that you are in fact guilty of these charges. Then listen as the state tells me what their evidence would be if this case went to trial.
Judge, there was a companion case in this matter in juvenile court regarding the dependency and neglect of the children. Originally, Mr. and Miss Lackey were charged as co-defendants. The state entered a dismissal in Mr. Lackey's charges and anticipated that he would testify in this matter if necessary. The proof would be that in August of 2024, the three children, GL, RL, and KO, of Ms. Lackey were in her care and custody. These children tested positive for narcotics on a hair follicle test, as did Mr. and Mrs. Lackey. Mr. Lackey would have testified that he was unaware that his wife had relapsed and that he was exposed similar to the children. The finding of dependent and neglected was entered regarding these children in juvenile court, and they are in the custody of a family member at this time.
Do you understand that's what the state's evidence would be at trial? You still wish to plead no contest according to this agreement. Are you satisfied with your attorney's services?
Yes.
You feel like Mr. Baker has done a good job of representing you competently? Mr. Baker, do you know of any reason she should not enter this plea?
I do not, Judge, and I may not have announced, but count 3 was also dismissed itself. I don't know if
All right, I made that note on the docket. Anything further from the state?
Judge, I do want to add that during this time, Ms. Lackey has completed some rehabilitation treatment and is on the road back to good choices. We would like to encourage her and hope that this time of probation will assist her in that.
And she's in nursing school now. She's doing a lot better.
All right, Ms. Lackey, upon your plea of no contest then in docket number 2024 CR 236 to the amended charge of attempt to commit a felony, I find you should be placed on probation under 40-35-313 for a period of 3 years, and you're ordered to pay the court costs. Count 2 is an amended attempt to commit a felony, and that it was likewise you will receive 3 years probation and be ordered to pay the court costs. You're allowed to have contact with the victim as permitted under the juvenile court order. People make mistakes in their life. You're a young person. You have plenty of time to correct all of the mistakes that you've made thus far, get your kids back, and have a productive future. But it's all going to be required for you to stay sober and stay away from the things that have basically brought you to this point. This is an opportunity for you to wipe your slate clean. Not many people get that chance, but you have an opportunity to wipe the slate clean and to start over without a criminal record if you do everything you're supposed to do. So I hope that will work out for you, and I wish you good luck. Thank you. All right, are we now ready? Anybody have anything else in the courtroom that I need to deal with before I bring out the inmates?
Got one announcement if you want to do a reset.
Let's get it over with so that, because
Page 48, Miss Deanna Selke, that's Mr. Atchison's case. They would like to move that till September 8th.
Ms. Selke will be moved to September 8th.
Thank you, Judge.
All right, bring out the first inmate.
First inmate's gonna be Ashley Ellis.
All right, good morning, Ms. Winnick, or good afternoon, rather. What do we have here?
On page 17 and 18 of the docket, we've got 2024 CR 172 and 2025 CR 286. We are currently working with the DA's office and have come to agreement. We would like to set this to both cases to May the 20th for settlement.
All right, it'll be 1 week from today, May 20th. We'll see you again next week. Thank you.
Up next, Judge, is Brittany Hale.
Judge, this is Ms. Brittany Dawn Hale. She's charged in one count with misdemeanor child endangerment. And Ms. Hale has no criminal convictions, and she would like to enter a plea to a 40-35 judicial diversion to one count of misdemeanor child endangerment. She's placed on probation for 11/29 on time served. Contact with the victim only is allowed by the juvenile court order and DCS dependent neglect. All jail credits are 5/8/25 through 6/4/25 and 3/23/26 through 5/13/26.
I just signed your order waiving the diversion fee, but I take it from that we don't have the confirmation from the department.
I'll try to put it in tomorrow.
So Ms. Hale needs to understand that if this is, if in fact she doesn't qualify for the 40-35-313, then it will be a straight up conviction on her record. Ms. Hale, raise your right hand. Let's place you under oath.
I do.
Thank you. State your full name for the record.
Brittany Dawn Hale.
Ms. Hale, you're here today charged on a single count of, I think it's child abuse or neglect. Pardon me. I have it right in front of me. But have you seen or been shown a copy of the charges against you and gone over with Mr. Brett Baker, the charges against you and the evidence that might be used to prosecute you so that you fully understand what you're charged with? Do you have any questions about what you're charged with?
I kind of wanted you to tell me a little bit more. You just said if I didn't qualify for something, what did that
I'll
mean?
explain to you. You have told your lawyer, and your lawyer is telling me that you don't have a prior criminal record, okay? I will accept that on its face value, but that's not sufficient for the legal system. We have to have proof of that. That means that you have to, in order to qualify for the judicial diversion, which is 4035-313, you have to prove that you don't have a criminal record by having the Tennessee Bureau of Investigation submit a search for your criminal history, and if they find you don't have one, then they send us a certification that you're qualified for this special program. It's for first-time offenders only. So what I'm telling you is that we're disposing of your case today to go ahead and let you out of jail and get you on probation. But I don't have that confirmation back from the TBI. They're going to send it in today, but it'll take a day or two to come back. In order to do this, they want to go ahead and enter this plea today. But if let's say it turns out that you have a hidden, not that you would lie to us about it, but there are people, believe it or not, who would come into court and misrepresent their past criminal history, try to get an advantage by saying, no, I don't have any prior criminal. Or maybe they had a case that didn't get dismissed and it wasn't cleared. I have to have confirmation that the record is clear and you qualify for this program. So if you don't qualify for some reason, if that TBI comes back and says that you don't qualify because you have some reason in your past that disqualifies you, then I have entered this plea to let you get out of jail today, but it will become a conviction unless and until the TBI tells me you qualify for that program.
So you mean I can't have been in trouble anywhere before at all?
You can't have,
I can't have been in trouble anywhere before at all?
well,
Can't have a conviction.
General Bryson,
So, Judge, what I see looking at the record in my file is that she does have some prior convictions on driving on suspended license, which we don't believe would be disqualifying.
Okay. I'm sorry, this is my first time, I don't know. I'm sorry.
It's okay.
Just because you're in jail doesn't mean you're disqualified.
I don't want to get farther into the jail, you know what I'm saying? That's all.
and you're not going to get in trouble. The only thing would happen is that if the TBI says, no, she doesn't qualify, then this will be a conviction that will be on your record. A misdemeanor conviction for,
Oh, okay, I thought you meant, okay.
Yeah.
Sorry, I'm so sorry.
that's all right. This is par for today's course, so there's nothing for you to apologize for. My job is to try to make sure that you understand what you're doing in the case. So, and I have no idea where I've gotten to at this point, but I'm going to start all over from scratch. Do you understand what you're charged with? You understand you can plead not guilty and have a speedy and public trial by jury. You understand you would have the right to have a lawyer and have one appointed for you if you cannot afford your own. You understand that if you went to trial, you'd be presumed to be innocent until such time, if ever the state proves your guilt beyond a reasonable doubt, to the satisfaction of all 12 jurors, and their verdict would have to be unanimous before you could be convicted. You understand that if you went to trial, you and Mr. Baker could confront and cross-examine all witnesses the state called to testify against you, and you could bring in your own favorable witnesses by using a subpoena. Do you understand that you would be presumed to be innocent? You would not have to testify or prove anything, and no inference of guilt would arise because you did not testify at your own trial. Do you understand if you went to trial, you were found guilty, you could appeal that conviction and the sentence imposed to the Court of Criminal Appeals and have a lawyer appointed to help you with that appeal? You understand that by entering this plea, you're waiving your right to a trial and to an appeal. All I'm going to do is approve what your lawyer and the state have agreed upon. To make it clear, we're going to assume that that form comes back from the Department of Corrections, or TBI rather, that says you don't have a prior criminal record that would disqualify you from this program. If that happens, then you're going to be on probation for 11 months and 29 days. And if that 11 months and 29 days is successfully completed, you do everything you're supposed to do. At the end of that year's time, so to speak, you can have your record expunged or wiped clean as though this case never occurred. But you need to understand that if you violate the terms of your probation, if you commit some new offense or don't do what you're supposed to do, then this will become a permanent conviction on your record. And it will be there in the future to make more severe the punishment you receive if you're ever again convicted of a crime. So as long as you stay out of trouble, you wouldn't have a problem. You understand that? The only reason it would become a permanent conviction of any kind is if they say you don't qualify for that. But I'm going to put this in the record, and then they're going to send me something that'll tell me whether or not it qualifies or not. And it will either, your lawyer will let you know, hey, it went through, you're fine, or it didn't go through and it's a permanent conviction. But you're not going to be revoked to serve time or anything just because it comes back positive. It's a paperwork thing more than anything. Does that make sense? Okay. So do you understand everything I've explained to you thus far? Do you want to plead no contest according to this agreement? All right. Is your decision to plead no contest today voluntary? Anybody forcing you to do this against your will? You understand that I have to have facts presented to me that would allow me to find you guilty even though you're not admitting anything. In other words, the state's going to have to tell me what their evidence would be at trial. So listen as the state tells me what their evidence would be at trial.
Judge, if this case went to trial, the proof would be that in October of 2024, a juvenile with the initials of RH was in the custody of Ms. Hale and her co-defendant, Ryan Hale. There was a DCS referral during the investigation. Both the child and Ms. Hale tested positive. Well, they had a hair follicle on the child, and then Ms. Hale had a positive drug screen for methamphetamine.
All right, I'm not asking that you agree with those facts, but you understand that's what the state's evidence would be at trial. Are you satisfied with your attorney's services? I feel like Mr. Baker's done a good job of representing you competently. Mr. Baker, you know of any reason she should not enter this plea?
I do not, Judge.
Then anything further from the state? Take it by their silence, there is not. Then in docket number 2024 CR 242, Ms. Hale, I find you should be placed on probation as to misdemeanor child endangerment under 4035-313, and you will be placed on 11 months and 29 days suspended probation, and you're to have contact with the victim only as allowed by the juvenile court order. Good luck to you.
Judge, up next is Amanda Roberts.
That's my case, Your Honor, and that's for disposition. After your other vote, excuse that bit, all right. All right. Your Honor, this is for disposition. Would you like me to read it out briefly for the court, Your Honor?
That's up to you, that's fine.
Yes, Your Honor. So we've reached a disposition with the state in this matter where Ms. Roberts will be pleading to count 1, aggravated burglary, and count 3, false representation of self as an attorney. And we have that the resulting punishment will be count 1 will be 4 years in TDOC at 100% to serve per the statute, suspended, and count 3 at 2 years in TDOC, also suspended, to run concurrently for an effective sentence of 4 years with required in-person probation reporting, monthly zero-tolerance drug screens, monthly restitution payments to the victim for a sum of $5,000 and glass door damages to be determined, which the general and I have agreed to coordinate to submit an agreed order for that indeterminate amount, Your Honor, and that Ms. Roberts must truthfully testify in order for this this plea to be entered. Counts dismissed in settlement are 2, 4, and 5, and she has pretrial credits from August 1st, 2025 through May 13th of 2026. May I tender this to the court, Your Honor?
Ms. Roberts, raise your right hand. Let's place you under oath. Thank you. State your full name for the record.
Amanda Murray Roberts.
Ms. Roberts, you're here today charged in a 5-count indictment, but it's indicated that you're going to enter a plea of guilty to counts 1 and 3. Have you seen or been shown a copy of the charges? Talked them over with Mr. Vassengill. You and he discussed the range of punishment you're facing as well as any possible defenses you might have. Well, it's indicated that you want to enter a plea of guilty. Do you understand you can plead not guilty and have a speedy and public trial by jury? You understand if you went to trial, you would have the right to have a lawyer and have one appointed for you if you cannot afford your own. You understand that if you went to trial, you'd be presumed to be innocent until such time, if ever the state proved your guilt beyond a reasonable doubt to the satisfaction of all 12 juries, and their verdict would have to be unanimous before you could be convicted of anything.
Sir.
You understand that if you went to trial, you and Mr. Massengill could confront and cross-examine every witness the state called to testify, and you could bring in your own witnesses by the use of a subpoena.
Yes, sir.
You understand you would be presumed to be innocent at trial. You would not have to testify or prove anything, and no inference of guilt would arise because you did not testify at your own trial. You understand that if you went to trial and you were found guilty, you could appeal that conviction and the sentence imposed to the Court of Criminal Appeals and have a lawyer appointed to help you with that appeal.
Yes, sir.
You understand that by pleading this guilty, you're waiving your right to the trial and to the appeal. All I'm going to do is approve what your lawyers worked out.
Yes, sir.
You understand that that is going to result in a conviction, actually 2 convictions that will be on your record in the future to make more severe the punishment you receive if you're ever again convicted of a crime.
Sir.
You understand everything I've explained to you?
Sir.
You want to plead guilty according to this agreement and waive your right to a trial.
Yes, sir.
Do you understand if you plead guilty, the court of the state may ask you questions about these offenses, and if you answer the questions under oath on the record and in the presence of your lawyer, your answers could later be used against you in a prosecution for perjury if I determine that you were lying under oath. Is your decision to plead guilty today voluntary?
Yes, sir.
Anybody forcing you to do this against your will?
No, sir.
You understand I can't accept your pleas unless I'm satisfied that you are guilty and there are facts to support them. Then I will ask you, are you guilty of this aggravated burglary charge? Or are we going to have a statement of facts?
We do have, Your Honor, we have a prepared written statement, and now that she's under oath, I would like her to have the opportunity to again review and execute if this is still a statement you'd like to submit. You swear and affirm it?
I swear.
And Your Honor, in lieu of asking questions, the state is going to rely upon her sworn statement. That you read through.
Well, I'm going to read it into the record, so. This is the sworn statement of Amanda M. Roberts. Comes now the defendant Amanda M. Roberts and would offer the following sworn statement in lieu of an oral proffer in open court. I, Amanda M. Roberts, do solemnly swear that the statements contained herein are the truth, the whole truth, and nothing but the truth, so help me God. My co-defendant Christopher L. King, herein King, and William Hagee, herein Hagee, were both in custody at the Dickson County Jail, hereinafter DCJ. King and I communicated by telephonically through the DCJ telephones and by text through the chirp system, also supervised by DCJ. On or about July 1st, 2025, King directed me to break into Hagee's real property located at 416 Wayne Duke Road, Charlotte, Tennessee, 37036, hereinafter Wayne Duke Road. King and I remained in communication telephonically as I broke into the premises located at Wayne Duke Road. On or about July 3rd, 2025, I decided to bring a document titled Standard Lease Agreement to the DCJ, which I did, and Hagee executed the same day. On or about July 1st, 2025, King directed me to bring a document titled Tennessee Durable Financial Power of Attorney to the DCJ, which I did, and Hagee executed the same day. On or about July 30th, 2025, I, at King's direction, impersonated attorney Roger Wanick. You, just out of curiosity, she impersonated Roger Wanick. That's a pretty good trick. To Hagee through text messages and advised Hagee to transfer his real property on or about August 1st, 2025. King directed me to bring a document titled Tennessee Quitclaim Deed to DCJ for Hagee to transfer Wayne Duke Road to me. King and I remained in communication, and I acted at King's direction throughout the incidents described above. And this is indicating that she has signed off on this the 13th day. So those constitute the facts. I'll have that marked as filed in this. Are you satisfied with your attorney services?
Yes, sir.
You feel that Mr. Massengill has done a good job of representing you competently?
Yes,
Mr. Massengill, you know of any reasons you should not enter this plea?
I do not, Your Honor.
Anything further from the state? Then Amanda Roberts, the docket number 2025 CR 202, upon your plea of guilty to count one, I find you guilty, sentence you to 4 years Tennessee Department of Corrections. That will be suspended and to probation, but if you violate your probation, it will be required to be served at 100% release eligibility. Counts 3, you're sentenced to 2 years in Tennessee Department of Corrections. That will also be suspended to run concurrently for an effective sentence of 4 years on probation. You will be required to go to report in person to probation, monthly zero tolerance drug screens, monthly restitution payments to the victim for $5,000 and a glass door damage to be determined, and you must testify truthfully if necessary, and to have no contact with the victim in the case. Counts 2, 4, and 5 are dismissed as a part of the agreement. Thank you.
Thank
She
you, Your
needs to, probably will need to talk to the probation department. We have another inmate.
Up next is going to be Carol Hughes.
This was Carol Hughes. Her case was previously set for a trial in March, I believe.
Sir, can I please speak?
It is unlikely we're going to be able to find a trial date before January, so we'll set it for one of the January trial dates. How about the 14th of January? Who is, okay.
General Sylvia.
I couldn't see you back there, General Sylvia. Yes,
Your Honor, may I speak, please?
wait a second,
Do what?
not yet. General Sylvia, is that a date available to you? You want to talk to your lawyer before we do anything else? Before you make a statement? Or you want to go ahead and make your statement, whatever it is you want to say.
Yes, sir.
All right, set for trial January 14th. Any other inmates?
Yes, sir.
Anybody else got anything? Are you the real Roger Wanick, or are you an impersonator? What do you have, Mr. Wanick?
Page 34, Aaron James Casort. Mr. Kusurik is here and present in the courtroom. We do need to arraign him, but then we also have a motion to modify bond conditions. Take care of the arraignment first.
All right, so is this, have you already been given a copy of the indictment?
I have, Judge, so we'll waive formal reading and enter a plea of not guilty.
Plea of not guilty is entered. I'll need to see the file. All right. The bond conditions are, it's a $250,000 bond. Bond conditions are to have a GPS monitor bracelet installed or released before release from jail, have no contact with the victims, no unsupervised contact with any minor children.
Judge, we filed a motion to allow him to have contact with his minor son that was living with him. His son is here, as well as family members too. His son was not part of any of these allegations or anything like that. And these allegations are, I think, anywhere from 6 to 11 years old.
State's position?
Judge, I don't have any grounds to oppose it. I also don't have any grounds to agree with it. I am aware that this child is subject of some sort of custody case in another county, but I do not know what type of case or anything about that.
Do you want to offer any proof, Mr. Wainick, or are you just making an argument?
Judge, I do have Christian Kusurik here. This is why this is the one that we did not want to be on Zoom. Do have him here if you want to hear from him. We can offer that, but other than that, we're just asking, I think, mentioned everything in the motion.
Well, based on the fact that under the motion, he has sole custody of this child, and this is a 15-year-old boy, without any other evidence to the contrary, it would seem to me that I should modify the bond conditions to allow him to have that contact.
I'll draw an order and have it submitted.
All right. That's the only modification.
Yes, that's all we were asking for. Thank you, Judge. Do not do that until I submit the
All
order.
right, we are set for trial unless something's happened in the last hour.
We do need dates on Mr. Kusurik's case after the arraignment.
Pardon?
We do need a date on the Kusurik case.
Status date for Mr. Kusurik.
Yes.
You want to make it September the 8th, I suppose? Let's do September 23rd. Try to spread the cases out a little. September 23rd.
Judge, I'll have an order first thing in the morning.
All right.
Thank you.
Jonathan Beck. Where is Jonathan Duff? Do we have Jonathan Duff in jail?
He was, his office advised us.
What are we
last
doing with
night
Mr.
that
Duff?
He was not needed.
It's just a reset, Your Honor. Mr. Duff has violations of probation that are set today. My hope for today was to get these reset to the June VOP day. He's got a status on his new charges in June.
Right, well, let's just set it for that June date.
Thank you, Your Honor. June 29.
All right, so we're set for trial on the Anthony Thompson case tomorrow morning at 9 o'clock. All right, I've got some issues I've got to deal with the lawyers in that case, so we need to bring the jury in at 9:30 in the morning, and then give me an opportunity to deal with the lawyers. We'll go from there. All right. Well, that concludes our business, so we will stand adjourned. Any of you folks any of the probation department that has orders you need me to sign, bring them up now.